wait for a direction to file an application because during the pendency of the appeal, a contract has been issued.
My lord, for the respondent, my lord, the work has already commenced under the tender. My lord,
No, extreme urgent, my lord. Otherwise, my lord, my entire matter would, my lord,
there was no stay.
It will become infructuous.
Yes,
What
my lord.
to do?
And the writ petition was dismissed, my lord.
Sorry, Mr.
Only one thing, my lord.
We can release it, happily release it so that you can.
No, your lordship would kindly not do that, my lord, because.
So then don't press for it. We will not upgrade it. Not fair. Then we have to upgrade everybody. Every matter is important to that particular person, litigant. As you think your matter is the most important matter, most urgent matter, every litigant thinks that.
But dude,
so be fair.
But I understand, but they are not being fair, my lord. They are issuing a contract during the pendency. That is my whole difficulty.
Very well. If you ultimately win, everything will go.
Your lordship, may I have leave to file for Union of India the CAN applications without e-filing, with the undertaking that I shall provide the scanned copy in pen drive, because my portal is not working and it has certain defects. And this is a very important matter. Much obliged, your lordship.
May I have your lordship's kind leave to mention for inclusion one bail in connection with appeal?
Inclusion, don't mention and waste time, please, sir. Just hand up the slip. You know, slip
Your lordship, may I permit to mention two matters? Item number 73 and 74 of your lordship's list, Delhi list. It's a NIA matter. Kindly fix a date for this matter.
Sorry.
Your lordship, the opposite party is here.
I was giving
Your lordship, just a date and a time.
No, what? Just a date and a time, as if that's nothing.
73 is press list. Then,
my lord, may I have my lord's leave to mention? May I, my lord's leave to mention two applications. My lord, these two applications are mentioned yesterday. My lord gave the leave for the matter to be listed today. My lord, despite that, the matter has not appeared. My lord, this matter will only take 1 minute. A similar matter was heard by my lord's last. My lord, if this can appear fairly at the top, my lord, that
Please understand, our regular court officer was absent, so maybe there was some. Today he is here, so it should be listed tomorrow.
Grateful, my lord.
Hey, that's group 9. What?
Yes, my lord. Group 9 hearing. Group 9. My lord, it will not take more than 30 seconds, my lord, not even a minute.
My lord, may I be permitted to mention a matter for admission of appeal, criminal appeal?
Lordship, regarding item number 88, this matter has been heard partly. So any day, Lordship, item number 88, at least 1 hour hearing was done. Rabin Singh. Any day, Lordship.
Appeal hearing.
Yes.
It's number 2 under appeal hearing. So whenever we touch appeal hearing, we'll take it up.
Lordship, may be permitted to mention one matter for original sale inclusion in the list, Lordship.
আছে কেউ?
Item number 1.
What correction?
My lord, it will be CRA 135 of 2021 instead of CRA DB. DB will not be there, but it's CRA.
Let the cause title of the order dated November 14, 2025 be corrected by deleting the letters DB, bracket में तो DB था, after CRA ta within inverted comma the. So let this correction be incorporated in the order dated November 14.
My lord, the second correction will be the quote of satisfaction, my lord, on paragraph 6. My lord, it will be
incorporate করার আগে that paragraph 6 of the order be also corrected by substituting. It will be what?
ACJM Ghatal Paschim Mednipur.
ACJM Ghatal, Paschim Mednipur. ACJM Ghatal Paschim Mednipur inverted comma in the place and state of our inverted comma additional chief judicial magistrate Paschim Mednipur.
Very good.
That's for a paragraph. Let these corrections be incorporated.
This matter I appeal for the state. My lord, in respect of CRA DB 110 of 2022, I was engaged by this honorable court by the division bench presided over by my lord Justice Bagchi, as my lord then was. My lord, in this matter previously, a report was called for by your lordships. There were 3 convicts, 2 and 3. 2 of them have preferred an appeal. Whether the third convict, whether he had preferred any appeal or not, on that score, a report was called for. Abdul Rashid and Ainul Hussain, they have preferred. Third convict is Shanawaz Akhtar.
He is not preferred.
No appeal preferred.
And my lord, I gather that in respect of CRADB 110, the appellant has directly appointed learned advocate. So lordship kindly releases me from this matter. They have already engaged.
You are appealing for in 110?
My lord,
Abdul Rashid?
Abdul Rashid.
Yes.
Very well. Hey, likhe now. Pursuant to our order dated November 4, 2025, the department has placed a report before us to the effect that Shanawaz Akhtar, Shanawaz, Shahnawaz, Akhtar, Akhter, has not filed any appeal against the judgment and order of conviction. Paragraph. Mr. Tumonto Ganguly, learned advocate, was engaged by a coordinate bench to represent the appellant in CRA DB 110 of 2024. Stop. However, it appears that the appellant has now briefed Mr. Mitter, learned senior counsel, not senior advocate. We are careful about with our words.
Well,
senior counsel to represent him. Stop. Therefore, as requested by Mr. Ganguly, we grant him leave to retire from the matter.
I'm extremely grateful.
Paragraph. The paper books are ready.
Yes, ma'am. I have
list the 2 appeals. Action.
one of the appellants, Ainul, he has preferred a bail and that is listed, my lord.
Oh. Correct. Okay. Let the application for suspension of sentence filed by the appellant in CRA DB 109 of 2024 be listed under the appropriate heading. Tomorrow?
Okay.
Tomorrow, date.
grateful, my lord.
You are appealing for him also?
Ainul and both of them.
Both. Paper book not prepared.
My lord, this has come as returnable. My lord, I have already taken out an application for bail in connection with appeal. Kindly post this next week. Mr. Saurabh Chatterjee, senior advocate, is leading me. Next week, my lord, Monday. No, 302. My lord, I have upgraded.
How long you have custody?
Well, 2 years, 7 months.
Only.
From a departmental note dated November 14, 2025, we see that the paper book is yet to be prepared. Stop. The department has asked for 6 weeks to prepare the paper book. Stop. Let that be done. Paragraph. List the application for suspension of sentence filed by the appellant under the appropriate heading on
Monday, my
yes, what date is that? 24 November 24.
Deep.
রোকা গেছে 74
Intercourt appeal hearing. Item number 5, 6, 7, 8, 9, 10, 11, 12, 13,
কৌশিক
14, 15,
তুমি ধরো না তুমি তোমার কাছে
16,
এগুলো
17, 18, 19, 20. Second. Item number 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Item number 21.
নেই চলো পাস ওভার
Uh, 22.
Lord, in item number 22, Mr. Kaushik Dey is appearing for the appellant. I'm praying for a week's accommodation, my lord.
admission of appeal week's accommodation on the request made on the prayer made on behalf of Union of India, let this matter stand adjourned for a week.
Extremely grateful, my lord.
Item number 23. 23
Section 5.
Have you served?
I acted on behalf of the state.
Served.
How much did they?
Also served prosecutings. Also have served.
What, 376?
Note 2, my lord.
376?
Apartment.
376.
My lord, POXO.
POXO.
Already have served 44 days delay in filing the instant.
Affidavit of service.
Being apartment.
For the appellant, my lord, it is a jail appeal. I have been appointed by the High Court Legal Service Committee. The 302 sole appellant, my lord.
Is there?
Sentence for life.
Is there any delay?
Well, that is the difficulty I find, my lord. Well, so far as the prisoner's petition is concerned, well, the sentence was passed on 30th of June 2025. Well, from the from the prisoner's petition of appeal, it appears well, it was sent to the registrar on 21st of August 2025. That means it is within time. But from the CIS, I find well, it was filed registered on 6th of September 2025.
Maximum few days delay, if at all.
3 or 4 days, my lord.
3 or 4 days.
If at all.
This is a jail appeal. This is a jail appeal. Stop. Delay, if any, is condoned on the oral prayer of learned advocate who has been engaged by the
High Court Legal Service.
High Court Legal Service Committee. So, paragraph, the appeal is admitted, usual order.
Great. Great.
What's the year?
25.
Pass over.
26.
My lord, this is a matter where Mr. Mitra was addressing, my lords. My lord, he's not in court yet. My lord, he will be here. May I only pray this, my lord, subject to my lord's convenience, if it can be kept at 11:30 or 12, my lord.
You have to also consider the court's convenience.
My lord, I understand. That's why I said subject to my every what
Pass over,
falls
pass
from
over,
my
sir.
lord. My lord.
My lordship, I am on behalf of the appellant. On the last occasion, my lord, it was found from the trial court's record that the appellant was below age. He was between 60 to 80. A CRAN was filed and still pending, my lordship.
Service upon the victim.
My lordship, a copy of the CRAN or the appeal.
Real application of.
It has been supplied to the prosecution.
Have you served upon the victim?
29.
Has it been served upon the victim?
No, it has been served to the PP.
No. State is another. You have to serve upon the victim as well.
My lordship, I need some time. I'll supply it to the victim.
But service upon the victim is not come.
Sir,
I'll make sure, my lordship, on the next date I'll definitely serve and come.
And your notice contains. Yes. So it was from Juvenile Justice Board.
No, my lord, if your lordship kindly sees order dated 12th of September 2025, which was handed over to us by the department, my lord.
order dated?
My lord, order dated 12th September 2025.
Where will we
Passed
get
by
it?
the additional sessions judge, my lord.
The trial court.
The trial court, my lord.
Was it 12th September?
The deposition.
No, my lord.
It
To my lord, this was handed over pursuant to this honorable court's direction. Both the parties have received this copy from the department. এখানে নিয়েছিলেন তারপরে পাঠিয়েছিল
So he was treated as an adult and he was convicted by the trial court. Although his age was found to be 17, but because of the nature of the crime, he was treated as an adult and convicted.
My lord, subject to your lordship's correction, whether the
disciplinary assessment was done or not?
whether the procedure that was followed while conducting this inquiry, my lord, conforms to the principles of law. My lord, so far as ascertainment of age is concerned, the first is matriculation certificate. My lord, here that was not produced. The second option is birth certificate given by the, my lord, first school excepting for the playhouse. This is a transfer certificate which was used by the sister. My lord, that doesn't come within those parameters. And the last option is the medical one, which is the ossification test. There is an indication that ossification test was held.
Also, and minor, 16 to 18.
16 to 18.
So, ossification test was there.
And we should let him serve and come back. Once, if we are satisfied, if we grant bail, then we can consider all these things.
Yes, my lord.
Let service of this application for suspension of sentence be effected on the victim of de facto complainant, and affidavit of service be filed in court on the next date. Paragraph. When shall we?
Next week, my lordship, any day.
Next Tuesday.
Next Tuesday.
Is the matter? Or, comma, retaining his position.
My lordship.
Why 2 crans? Hello. Why 2 crans?
Lordship, I have filed the number 2. First one was disposed of.
Why?
ওই যে একটা অর্ডার
Item number 30 to 33.
No, 32 I am appearing.
30 and 31, my lord, I'm appearing, my lord. I'm led by Mr. Mukherjee, my lord. I was only praying for a short passover, my lord. Because there is one, in 30, my lord, one petitioner, his medical report has been submitted before this honorable court.
You want a Passover, take a Passover or argue?
My lord, Passover.
Can it be at 2 p.m.?
I'm for
Given the judgment itself, only the depositions.
34.
Well, two petitioners are before your lordship. Julfikar Boidu and Swadesh Mukherjee out of 5 convicts. Now, my lord, the last rejection kindly takes up, my lord.
2 petitioners in the same applications.
No, 2 other applications. 3 and 4. My lord, kindly takes up Cran 4 first. Kindly see page number 10. Cran 4.
Cran 3 SJ.
Cran 3 also came, my lord.
Not both are together, my lord. So as my
The department has filed a report dated
Yes, my lord.
14th
Cran,
November.
I went there yesterday.
It has come now.
Yes, my lord. My lord, kindly takes up page 10. It was the last rejection of petition number 4 in 4. But I am so far Cran 4 is concerned, my lord, I am renewing my prayer because, my lord, kindly sees the order at page 10. Bail prayer of the appellant was never rejected earlier. And, my lord, the witness could not identify this appellant at the spot.
No, this Rahmatullah Shortar and others. Who are these others?
Yes, my lord. I have seen the Cran 2, but the Cran 2 only filed by Rahmatullah. But in the order sheet, it came wrongly.
Your petitioner name is Julfikar Boiddo.
Yes, my lord. Julfikar Boiddo. It was filed by Julfikar Boiddo only. Ran 2.
Ran 2 was filed by Julfikar Boiddo.
Yes, my lord.
It was filed by Julfikar Boiddo.
Yes.
And Tran 4?
Tran 4 filed by Julfikar Boiddo. I'm renewing prayer for him because, my lord, the reason given here that bail prayer of the appellant was rejected earlier. But that's not the fact. Never he came for suspension of
Sir,
sentence.
please understand. Let us understand.
Yes.
Tran 2 was filed not by Rahmatullah,
No.
by
Boiddo, Julfikar Boiddo.
And Tran 2 was dismissed.
It was dismissed. And the order sheet is at page 10.
Yes.
And kindly sees the order sheet. We have considered bail prayer of the appellants were rejected earlier on merits.
Forget about that.
Yes, ma'am.
Then they were identified.
Yes, my lord. They were not identified.
They were identified.
I am showing, my lord. Kindly sees, my lord, page number PW 33 and
111.
yes, 111.
Page 111.
The TIP was there or not?
My lord.
Yes, TIP was there. This petitioner was never identified in TIP also. In court also, they was not identified.
Is it correct?
Not Swadesh was identified.
Swadesh, I'm coming.
Sir, Julfikar Boiddo was identified in
Not identified in page number 111.
111.
Rahmatullah identified. Sanjay Sarkar identified. Ijul Naskar identified. Julfikar Boiddo was not identified.
That is on doc. That is during the evidence.
Even in TI parade.
I have to
Yes,
consider. Witness accused Sanjay Sardar, this person had two revolver on the head. The person was making search in the entire flat.
But so far TI parade is concerned.
The witness person was standing on a how many accused were present at the time of this
incident?
Recording of evidence at that time. Maybe your petitioner was not present. You have to show that during the process of.
But during TI parade also he was not identified.
Was he placed?
Yes.
Now the allegation is that these four persons were there, and one was a mason, one was a security guard. They were seen speaking at the ground floor together, and then this evidence states that.
Now, what is the findings of the
Yes, I'm coming to that.
regarding the identification of this Julfikar Boiddo? How is that?
Identification of Julfikar Boiddo, he was never identified. There is no finding. So, my lord, the finding was he assisted to the other three accused persons. But
assistance called abatement or conspiracy.
yes, my lord. No documents, no evidence to show that I have assisted them.
Well, okay, so there is no incriminating evidence against Julfikar Boiddo.
He was very much there. The deposition states that he was in the ground floor. He was seen speaking to this person. The one who was identified.
But
he was a mason, and the other was a security guard. The allegation is.
I am showing, my lord. I am showing kindly.
The allegation is
page
recorded
number
murder.
25.
I am asking her. Then we shall reject.
No, sorry.
We have no time. So much time.
No,
we want to go through the deposition in a very short time. Where is involvement?
Shall I get back with the depositions the
Yes.
other day?
Come back.
Fine.
Come back, analyze, come back. Show us what is there against Julfikar Boiddo.
He is saying that there is no identification. No,
Only not today.
Give me a
we
copy.
are helping you.
অ্যাপিল তো তুমি করছো অ্যাপিল তো তুমি করছো আছে তো অ্যাপিলের ফাইলটা তোমার
আমি কত রিপোর্ট 18
Item number 35. 35, I am appearing for state.
Next. Pass over.
Item 36. My lord, I am for the appellate.
State 36.
Are you not doing it? Well, I'm praying for not. এই পেপার বুকটা আছে এই
Paper book হয়নি।
ও
TCR
করে দাও।
incomplete.
আচ্ছা ভালো কথা তাহলে
The prayer meet on behalf of the state. Mama, let this matter stand adjourned for the day.
Lordship, I am praying for short pass over. Mr. Mukherjee, learned senior about the appeal.
Pass over. কোন ছবি? 71 অব্দি আছে।
38.
My lord, I am appearing on behalf of the victim girl being appointed by High Court legal aid. My lord, I am appearing on behalf of
Video service do they? It counter double. Two times have served has none appear. Affidavit of service not two times have released. Malad case under section second time I'm filing this bail application. Malad 376 2A and section 4 of the POCSO Act. Sentence 10 years
First time I am moving. De facto.
Who is in 40?
39 to 45.
My lord, so far my application is bail is concerned, my lord. I am already paying more about 11 years.
Life.
Life.
302.
302. Also POXO. 378.
Item number 41 to 45.
I'm appearing.
But I'm in 45.
My lord, I'm in 41.
And I'm in 43.
I'm appearing from 41 to 45 as a special public prosecutor.
One by one. Maintain 41 first.
41. My lord, may I just say something? Submit, my lord. Even, my lord, the state had filed appeal for enhancement of, my lord, the sentence.
Grand one.
Yes.
Grand.
I'm just passing the, handing over the copy of the order.
GA number 6.
Engagement. Yes, who is in 41?
41, Mr. HON'BLE is.
But it arises of the 41 to 45, it arises from the same order. We appreciate that, Mr. Ahmed. We understand that. We are asking who is appearing in 41.
This one I'm appearing.
Yes. Yes. You have a CRAN application for bail. Move it.
Who is for the state?
41 minute, I am appearing on behalf of the state. My London State is a special public
Depend?
Special public prosecutor by the PID.
Oh.
You don't want to move it, don't move it. It's your application.
Lordship will take up all the matters together. Yes. Lordship will kindly fix up all the matters together and fix up a date.
What fix? Today is the day, Mr. Apuli. All matters are before us.
I was of the impression that there will be joint prayer. Let the matters be taken up on Tuesday.
Make that prayer, we'll take it up on Tuesday. Wednesday is tomorrow.
That was already settled outside.
Tomorrow. No, next Wednesday, because on the
one prayer, my lord, subject to Lordship's confirmation. My lord, but in fact, my lord, two prayers. First one is that, my lord, I am in item number 45. My lord, I have gotten information from the wife of my client that she is suffering from some kidney ailments. My lord, later reports be called for from the my lord, superintendent of jail of Midilpur Correctional Home, Central Correctional Home. That is one.
Who is suffering? The accused, but the convict or?
Convict.
Yes, second?
Second one, my lord, instead of Wednesday, if this can be fixed on Friday.
Friday.
Only this much.
Friday.
Next Friday.
Friday week.
Friday week.
Friday week, I'm not available.
Then give us a date. Discuss amongst yourselves. Give us a.
বুধবার ওর অসুবিধা আছে তাহলে 1 তারিখ করুন না
First of December. First December.
First.
All say yes.
As jointly prayed for by learned advocates for the parties, let these matters 41 to 45 একসঙ্গে stand adjourned and be listed again on December 1, 2025 paragraph. Learned advocate for the applicant in appellant in CRA DB 79 of 2024 says that the appellant is suffering from kidney related disease. Stop. Let the superintendent of the which correctional?
Midilpur Central Correctional.
Midilpur Central Correctional Home file a report regarding this health status of the appellant, on the next date. Midilpur Central Correctional Home.
Central Correctional.
Paragraph. Registry is directed to immediately communicate this order to the superintendent of Midilpur Central Correctional Home. Stop. Learned advocate for the appellant in CRA DB 79 of 2024 is also requested to communicate this order to the superintendent Medipur Central correction.
My lord, it has been brought to our notice by the learned special public prosecutor that a GA6 of 2025 has been filed apparently for enhancement. My client has not been served with a copy. We do not know whether we are also party to this. So, my lord, if just to avoid any further delay, let this be added to the list also, and a copy may be served upon all of us. And
GA is what? Government appeal?
GA6 of 2025 for enhancement. That's what my learned friend is submitting.
Next, GA means government appeal.
The government appeal.
We are further told that the state has filed an appeal in which matter? In all this?
Only one matter. Or challenging the impugned judgment, my lord, perhaps.
Oh, I see. An appeal against the judgment and order impugned in these appeals, being GA6 of
2025,
for enhancement of sentence.
Right.
Stop. Let GA6 of 2025 be listed along with these matters on the adjourned date.
And let a copy be served upon us.
That you tell Mr. Ahmed, he'll give you.
Sir, copy deven naki judge sahib order korben?
Well, I had already served and moved it. It was before the earlier. Your learned friend is requesting you, Mr. Ahmed. You give him a copy, he'll give you a cup of Darjeeling tea.
A great bullet. Great bullet.
Deep.
GA625.
Item number 46.
Your Lordship, I have this briefing led by Mr. Public Prosecutor. Your Lordship, on the last occasion, Your Lordship has called for the report regarding whether the complainant has been informed or not. Your Lordship, this is the report.
Whether
De facto complainant has been informed or not. I have had
service report, I
Yes,
see. We cannot service report. Madam, we dictated an order 2 days ago, last week, regarding the format of the notice. The notice should mention that the victim or the de facto complainant, if she so wishes, will be entitled to legal aid.
Your Lordship, I have asked the IO to intimate the family of the victim so that she can come and meet with me. But Your Lordship,
That is not in the notice, at least.
then I shall call for a
They have also asked you to circulate that notice.
Yes, the order that we dictated, which mattered, we don't remember. We directed the office of the public prosecutor to circulate that order amongst the learned advocates who appear in these matters, state advocates. Sir, কি করবো? Notice দেবে একটা?
Notice to the
Service report filed by the state be kept with the records. Stop. Paragraph. We see that the notice that was served on the victim oblique de facto complainant does not mention that the de facto complainant entitled to legal aid. Stop. In other words, if she so desires, the state, the legal aid committee shall engage a lawyer to represent her, for which he shall not have to bear any cost. Stop. Let a fresh notice be served on the de facto complainant in the light of this order, in a language which would be comprehensible to the de facto complainant. 1 week. Next Tuesday. Next.
Item number 47.
At 47, may I pray for an accommodation?
Not today.
But Thursday, my
No, except on the 23rd.
Friday, my
On the request of learned state advocate, let this matter stand adjourned and be listed again on Friday date.
very first. Grateful.
With 49.
48 was rejected yesterday, my lord. 49 is before your lordship.
49. Chalo, next.
That's it.
48 is disposed of. 48 is disposed of.
Was disposed of yesterday.
Well, item number 49. The copy of the applicant. I'm being led by Mr. Chavi Ramek in this matter. I'm just praying for not to get my lordship.
On the prayer 49 টাই করবে এই 48 disposed of হয়ে গেছে বলছে উড়িয়ে দাও লিস্ট থেকে on the 49 করো on the prayer made on behalf of the appellant oblique petitioner let this matter stand adjourned for the day.
Item number 50.
I am praying for not today on behalf of the state.
Not today.
4 years out of 10 years NDPS.
On the prayer made on behalf of the state, let this matter stand adjourned for the day.
My lord, I am for the appellant, my lord. My lord,
I advocate on behalf of this.
my lord, kindly fix this matter on Friday, my lord.
On the request made by learned advocate for the appellant oblique petitioner, let this matter stand adjourned and be listed again on Friday date দিয়ে দাও
আমরা দিয়ে দিয়েছি
Mr. Dattu appearing in this matter.
State.
The conviction under section, there are four count of offense. Section 3, Section 5 and Section 6 IT Act already served out. No POXO. IT Act 2 years, Section 5 IT Act 7 years, 6 7 years, and 370 maximum punishment is available 10 years. Out of 10 years, 8 years, 6 months already served out. And paper books are already, TCR is incomplete. It is mentioned in the list.
Yes, daran.
Just but I've got the set. But my junior is not present, but I've gone through it, my lord. He was identifying the TI paragraph. Page 40, 17 and 18 is the judgment loss page.
But I'm not on merits, but only
17 and 18 of the judgment.
He is not on merits. That's only he has identified the TI parade page 17 and 18 of the
All right.
Another is the victim, my lord. The PW5, the page 12. My lord, come to the page 12, lordship. Sorry.
8 year, 4 months.
Yes, 8 year, 5 months, more than 8 year, 5 months.
All right, Mr. Datto. Anything else? 8 year, 5 months he has served out of 10 years.
Just I discussion of lordship. It's my duty to just.
Yes, yes. You have duly discharged your duty.
These are duties. And paper book is ready.
Yes. No, paper book is not ready.
Let it be ready.
TCR is incomplete.
Yes. Give direction upon the department lordship to matter take up serious.
So post conviction, you are there for about 2 years.
Yes.
2 years, 2 months.
Yes,
2 years.
And throughout the trial, I was in.
The applicant prays for suspension of sentence pending disposal of the appeal that he has filed against the judgment and order dated September 14, 2023, passed by the learned additional district and sessions judge, fast track, third court, Diamond Harbour, South 24 Parganas, in case number ST9 (07) 2018, whereby the how many accused were there?
There 3 were convicted.
3 convicted. Whereby
I am for 1 only.
the applicant and 2 others.
Meena Singh. My lord?
Meena Singh.
I am for Meena Singh only.
And 2 others were convicted under sections 370/120 capital B of the IPC and also under sections 419.
No, my lord. 3151D 61 IT Act. It's mentioning the cost.
No. This is also there. 419/376.
The cost title is mentioned, is there?
376.
Penal and IT.
Yes, 419.
419.
Not me. That is Farooq Ali and others. Not Meena Singh. Not Meena Singh.
Right.
Not Meena Singh.
Meena Singh is only 370/120 B.
And 3(1) this IT Act. Can you see the cost title?
And section
4 count.
And under section 33/5(1) D (6) of Immoral Traffic Prevention Act 1956 and was sentenced to suffer 10 years imprisonment. So, paragraph, the applicant says that she has already spent more than 8 years, 5 months
Yes, ma'am.
in custody. Stop. Throughout the trial, she was in custody. Stop. She has served out a major part of the 10-year sentence. Stop. The appeal is not even ready for hearing. Stop. It is anybody's guess when the appeal will be heard. Stop. On this ground, she prays for suspension of sentence and grant of bail. Paragraph, learned State Counsel opposes the prayer. Stop. He draws our attention to the evidence on record. Stop. He says that the applicant was duly identified as one of the offenders. Stop. he says that no leniency should be shown to the applicant. Paragraph, we see that the applicant is already in custody for more than 8 years, 5 months. Stop. The maximum punishment that has been imposed on her is to suffer 10 years imprisonment. Stop. From a departmental note dated July 23, 2025, we find that as on that date, the department found the trial court records to be incomplete. Stop. Therefore, in all probability, paper book has not yet been prepared. Paragraph, in view of the long period of incarceration of the applicant and there being practically no chance of an early hearing of the appeal, we allow this application. Kure usual terms.
But she's a resident of Uttar Pradesh.
Yes, my lord.
So she has to
Civil
be
in
Kolkata.
24 Pargana. This is a case of 24 Pargana.
No, we are now hearing.
No, my God.
So
I leave it up to you.
She shall reside in within the PS.
Yes.
Metia Buruj.
And I leave it up to you.
Metia Buruj and report to the report Metia Buruj.
Shall not leave.
Shall not leave the best of us.
Shall not leave the Kolkata.
তুই তো বলছো মেটিয়ে বুড়িস পিএস এর ভেতরে থাকবে তাহলে আর কলকাতা লিভ করবে কি করে তাহলে বন্দি শুনে হ্যাঁ
She shall not leave
24 per South 24
metropolitan limits of Kolkata. হ্যাঁ metropolitan limits of Kolkata. ঠিক আছে?
Say she will again resume her business.
No, entire proceeding, my lord, I am not on marriage. Entire proceeding without
Granted, disposed of.
Very good.
Appeal to act order karo. The department shall file a fresh report as regards the status of the appeal and in particular whether complete trial court records have been received by it, on next Tuesday date when the appeal will be listed under the heading to be mentioned.
So she shall remain within the jurisdiction of Metia Buruj PS.
My lord.
Okay, because we cannot direct her to
my lord
meet the
Metia Buruj PS.
Metia Buruj PS, excepting for the purpose of and she shall report the current address.
Yes,
to the learned trial court.
If we can't take up the matter on Monday, Lord, 53.
53. Yes. On the request of learned senior counsel representing the appellant, let this matter stand adjourned and be listed again on Monday date the other.
Thank you. 54. I am for the appellant in 54. I am led by Mr. Jana. If I could just start the matter, Lordship, you would.
That's my brief.
I'm so sorry. So sorry, sir. I'm so sorry.
Date 54.
No, it's all right. No.
My lord, I have 2 points, one on fact and one is on law. My lord, this appellant, he has been convicted under section 395. My lord, for once, may I take your lordship once to page 23 of the judgment. My lord, decision with
Only
reason.
395
Only 395 against me.
to 76D.
No, I have not been convicted under 376D.
There are-
My lord, I shall take your lordships to the order part also. My lord, page 109.
No, why you did not register your friends not to commit rape?
My lord, may I just come to that? My lord, kindly sees the charge. The charge is under section 395. Now against 4%, the charge itself is defective. Page 23. Page 23 of the judgment.
Yes.
My lord, kindly sees, may I read, in this case, charge were framed against all the accused persons under section 395 Penal Code of Indian Penal Code and separate charge under 412 376D of the Indian Penal Code against Ramjan, Abdul Hamid, Dhanu and Imam. I am Abdul Hamid. Now, in the next paragraph, the learned trial judge was pleased to quote the section. My lord, kindly sees, section 391 says, it is quoted there, when 5 or 4 or more persons. Now, the primary element to constitute an offense under dacoity, my lord, requires participation of at least 5 persons. There was a charge which was framed.
What is the FIR?
FIR was against, yes. Now, my lord, may I just inform the
Maybe 2 or 3 persons
No, my
are
lord,
not
my lord, may I just
apprehended.
inform?
So then it will come to 394. Sir,
My lord.
it
My
will-
lord, the
it has
FIR
to
was
be
against
framed.
unknown persons. FIR were against unknown
Maybe.
persons.
That
Now,
is-
my lord, 5 persons, they were arrested during the course of investigation. Now, the charge sheet was filed against 4. One was not sent up for trial. That is also there on record. The charge sheet was filed. The case was started at 395. 5 persons, they were arrested during the course of investigation. The
So
charge
what-
sheet was
what-
filed.
What should have been the exact charge?
My lord, it
394.
should be under robbery. Under robbery, if court finds that
So
dacoity has committed.
we shall reduce the punishment if possible. We shall
Very well. In that event, my lord, if it is robbery, highest punishment is 10 years. This appellant is in custody for 8.5 years. As on date.
Only thing we can agitate right now.
Very well. And my lord, on
I
facts.
guess the charge sheet was submitted against 5.
No,
Your Lordship
one-
sees page
no.
9 of the judgment, internal page 9, Sheikh Ramjan, Imam Sheikh, Abdul Hamid
So
initially,
you have got 10 years.
8.5 years.
and Thanu and
No.
Ibrahim thereafter.
8.5 years I am in
Sentence,
custody.
punishment was for 10 years.
For life. And if
Well,
it
for-
boils down to robbery, it will be 10 years highest punishment. My lord, even if it is so considered, then also 8.5 years I am in custody.
But he's saying that there is a.
My lord, kindly
charge has
sees, one person has already been acquitted also.
That is different.
Well, that is different. But from where that he was never sent up for trial. My lord, may I just read page number?
Internal page 9 of the judgment.
May I just read that?
Yes. Let Mr. Jana finish then. Please carry on.
My lord, may I just read?
Page number?
Yeah, first time. Now, my lord, page number 20.
Yes.
Page 20 of the judgment. It is recorded
that one suspect, namely Sheikh Akram, who was not identified and was discharged from the charge sheet.
Page number 20.
20.
Para number
6A,
6A 13.
bracket 13, in the mid portion, after taking charge of investigation, he seized many articles from the place of occurrence and arrested one suspect, namely Sheikh Akram, who was not identified and was discharged from the charge sheet. Now, the moment a person is discharged from the charge sheet, therefore, there were 4 persons altogether. That charge sheet, that report was never challenged by the de facto complainant. Now, there are altogether 4 persons. For that, my lord, in page 23, the learned trial court recorded that during the framing of charge, the charge was framed against 4 persons. Kindly see then page 23.
According to Learned State Council, that charge
Now, my lord, the
charge sheet against 5 persons.
I find from the body of the judgment, page
but
9,
this is
half
also
paragraph,
recorded.
and page 10, first paragraph. My lord, page 9, point E,
Page 9.
internal page 9 of the judgment. Point E.
No, there are 5 persons.
My lord, now kindly see, my lord, one was acquitted, discharged.
No. You will come to the 23 page number. In this case, charges were framed against all accused persons under section 395. And separately, charges under section were framed against accused Sheikh Ramjan, Abdul Hamid, Dhanu Sheikh, along with it. So there are 4 persons as per
376D.
23 is concerned.
376. Now, my lord, page 20 says, 19 says, one person was not sent up for trial. One person was not sent up for trial. It remains 4, and I have been acquitted from the charge under 376D. Only 395 is against me.
Imam Sheikh. Imam Sheikh.
So you are not ready, I think.
No, my lord. Here, my lord, when the judgment begins,
and Sheikh Ibrahim has
name.
Yes, judgment begins.
The name of 4 persons are cited.
Yes.
At page 9, we find initially charge sheet against 3. 2 were shown as absconder, thereafter 2. So total 5 were finally charge sheeted. Page 10, 5 of them had been charged. Okay. But I do not find the name of Imam Sheikh.
Imam Sheikh died.
Hello?
Imam Sheikh died.
Yes, that is why he.
That is what is written
during
here.
trial.
Yes.
So that is different.
That is a different
That is different, my lord.
At the time of commission of offense,
All the time
5 persons were there. At the time of commission of offense, 5 persons were there.
My lord, that is the case of the prosecution. But when they filed the charge sheet, they did not send up 1. Now it becomes 4, for which the learned trial court has filed the charge as against 4.
So was the charge sheet from CD.
Do not have anything. Record charge sheet.
Charge sheet and my lord, page 110, I find Sheikh Ibrahim, he has been acquitted from the charge.
আসেনি না
না LCR টা নেই
দেখো এটির জন্য লাইফ দিয়ে 376
my lord, the LCR কি এসছে এটা
but he has not been held guilty.
Oh, sorry. Trial court record has not come.
Then
trial court record is also not.
Then I have to see the charge sheet. Bring charge sheet and
Is DC no, Mr. Jana, you see, there's a note of the department. July 25 note says TCR has not yet arrived, but let us call for a fresh report. We don't know. Oh, we had called for a fresh report. কোথায় কিছু দেয়নি তো?
No, the report was already called for.
Yes, on 7th November. কিছু এসছে? নাকি তোমরা ফাইলটা পাঠাওইনি নিচে? ডিপার্টমেন্ট জানেই না যে আমরা রিপোর্ট চেয়েছি।
ওইখানে পেন্ডিং তো, ওইখানে পেন্ডিং।
কি?
নোট তো দেখেন নোট
Calcutta. What? What do we have?
But matter, my lord, kindly take the matter on Friday, my lord.
56.
On the request made by learned advocate for the applicant,
My lord.
let this matter stand adjourned and be listed again on Friday date. The next
57.
Yeah, could be. Well, allegedly, the person who died was administered poison. He had two wives.
He had
two wives. Now, the second wife, children, and the wife are the appellants before your lordship. There was a dispute over property. So, according to the prosecution case, the only, if I may say, the evidence which has been led is a statement of a civic volunteer who allegedly video recorded the person who died his dying declaration. That's the story. Now, when the civic volunteer comes to court and he says no videography was done, nothing was said, and the IO says this gentleman, civic volunteer, never told him about the incident. Malad, there is not even 4 persons are for your lordships, all family members. Malad, there is not a single whisper about three. Not a whisper about how the poison was administered, because the post-mortem report, Malad, I'll just show to your lordship the post-mortem report. Well, I'll just show to your lordship.
What is the name of the deceased?
Hanif.
Deceased is Musharraf.
Hanif.
Musharraf.
Malad, please seize this post-mortem. But nobody has said it. I would like my learned friend to say who actually administered it.
No, one second.
Yes, Malad.
Applicant number 2 is Jannegar Bibi. He is Musharraf's wife. Second wife.
Second wife.
Who is Parveena Begum? Shuli.
A relative.
And Chonchol Sheikh. I see. Chonchol is Parveena's husband.
Son.
Daughter and son.
Daughter and son, my lord.
Chonchol Sheikh is Musharraf's son.
Son.
And
Second
Parveena
wife.
is the daughter. By the second wife.
Second.
Very well.
Well, I'll just show your lordship the post-mortem report. Just seize. Well, the entire trial was conducted without the forensic report. No FSL, nothing.
What is the chemical report?
PW1 onwards, may that my kindly see.
No,
I have to do a chemical examination report whether it has actually poison or not.
No.
Then,
no chemical report.
No.
Then,
But my lord, they are the materials.
yes.
They are
Allow hard to.
No, I must say.
PW1 onwards.
Well, how can I change myself? I'm trying to change myself.
No, right. We have given sufficient time to you.
My lord, since the paper book is ready, the appeal can be heard because. Sir, the last order, my lord. May kindly see the last
Out
order.
of 3 appellants, two are.
My lord, kindly see the last order once. They agreed for preparation of the paper book because the coordinate bench wanted to hear out the appeal itself. That was the order they agreed.
You may both agree anything. You may agree.
Since the last order speaks of this, so I pointed this
When
out.
do we hear? When do we hear?
Correct.
Group 9. Residuary appeal accepting police.
Whether there is an arguable case on the
My lord, PW1 onwards.
PW1, yes. Why?
The deceased
Why PW1?
told the name of the assailants. I am reading from the judgment, my lord.
Oh,
no, PW1. Evidence to the okay.
Sir, আমার কাছে depositions আছে, sir. My lord, running page 10. Running page 10.
Yes, paragraph.
Paragraph 14.
Yes.
PW1 is the son of the victim who deposed by saying that on this date at about 9 a.m. while he was going to have tea, some persons told him that father has consumed poison.
So some persons.
He found his father was inside the house. He broke open the padlock. It was locked from outside. He entered the house. When he asked his father what happened, he informed him that when he returned home and asked for a glass of water, the accused persons provided him water mixed with poison.
Oh, but 164 statement.
My lord, 164, he has named 3. In the FIR, in the depositions, they have named everyone.
But
The
where
164 is the exhibit, my lord.
poison I think is right away.
How long in custody?
Well, I was a bail and
April
then
2025.
25.
Conviction. You were throughout on bail?
Yes.
All three?
All
Yeah.
And he has named.
The
This
Senate
is
Council
a-
for the petitioners has submitted that petitioners have been falsely implicated in this case. Stop. There is no clinching evidence against the present petitioners, but in spite of that, they have been convicted. Stop. There is no eyewitness to the alleged incident. Stop.
Hey, to
The
column ki cross.
alleged poison
I don't
or
know.
viscera. Viscera was not sent.
No, it was sent, but the report never
is
came.
not there.
তো এটা ভালো কলম দেখো নিস না
The viscera was sent for chemical examination, but no report was received from the forensic laboratory. Stop. The petitioners were all along on bail during trial, and there is no allegation that they misused the liberty imposed upon them by the learned trial court. Stop. Para. The learned counsel for the state opposes the prayer for bail. According to her, there are sufficient incriminating material, sufficient incriminating evidence against the present petitioner. He has drawn our attention to the deposition of PW1, the de facto complainant.
Yes.
Also.
The PW1. What is his name?
Lord, PW2, my lord, running page 12.
PW1 and other witnesses. Stop. She has also intimated that paper book is ready, and there is a possibility of an early hearing of this activity of para. We have considered materials on record and found that the viscera, although the viscera was sent for chemical examination, no report is received or no report is exhibited. No report is exhibited to show that the death was due to consumption of poison. Stop. However, the postmortem report, the comment of the postmortem report in this regard is inconclusive, since there is no chemical examination report. Stop. The petitioners have an arguable case. Stop. They were all along on bail during trial. Stop. There was no allegation that they misused the liberty granted to them. Stop. In view of the above, we are trying to allow the prayer for bail on certain condition after suspending the order of sentence.
ACGM Rampura.
Each subject to a section of ACGM, and they shall not leave jurisdiction of Rampur.
The two Passovers matter, can I do it tomorrow?
Item number
30 and 37.
Kaushik, 30 or 37 not today করে রেখে দাও।
30 connected matters.
Connected.
30 to 33.
30?
232 are connected matters.
33.
30 to 33.
30 to 30.
31, 32, 32, 33. 30 থেকে 33 বুঝেছো?
আর 37. আর 37 দাদা. Grateful.
Daku.
58.
On the prayer made on behalf of the appellant, let the matter stand adjourned for the day.
'59.
Yeah, madam, for that. Give it to service. One of the appellant was convicted and sentenced to suffer rigorous
Which body
imprisonment.
Not today.
My lord, Thursday.
Particular Thursday, I have a fixed matter. My lord, let it be on Wednesday, tomorrow. Kal ke ko. No, let it be on Thursday.
On the prayer made on behalf of the state, let this matter stand adjourned and be listed again on Thursday date. How's senior doing? All right.
'60. Pattern number 60.
60 and 61 are the
60
connected matters. So Lordship, on behalf of the state.
Lordship, I'm praying for a week's accommodation.
Why? Why?
No reason.
On the request made by you appearing in both 60 and 61.
61, mine one is the 61.
He's asking for accommodation.
Connected matters.
On the request of learned advocate appearing for the appellant in CRA DB 188 of 2025, let these two connected appeals stand adjourned and be listed again on 26th. November 26th.
Sleep. Deeply of it.
Backward. 62.
62, my lord, I am for the applicant. My lord, conviction under section 304 part 1, 10 years. My lord, I was granted, my lord, anticipated bail. I was on bail during trial, my lord. I have never
And you are convicted.
No, my lord, what?
You have forgotten that you are convicted. Why you are saying that you are anticipated bail? Huh? Committed murder.
304 part 1. My lord,
how long you are in custody?
My lord, now I am in custody for about 18 months.
8
No,
months.
8 months. Sorry, I beg apology. 8 months. 8 months.
Only 8 months. And throughout.
Yes, Mr.
There's an eyewitness PW6. Lordship
What did he do? What did he do?
There was an altercation between the deceased and the appellant. The Lordship just for a moment comes to page 15 of the judgment. It cannot be said that this happened in a fit of rage because the accused went back to his home, collected the wooden lock, came out and then beat.
Throughout on bail,
True, my lord.
the applicant was convicted under section 304, bracket A, part Roman 1, bracket closed, of IPC and was sentenced to suffer rigorous imprisonment for 10 years by a judgment and order dated March 19, 2025, passed by the learned additional sessions judge, second court, Howrah, in ST number 2604 of 2014. Stop. The applicant now prays for suspension of sentence. Stop. He says that he is in custody for about 8 months. 8 months. Stop. Paragraph. Learned advocate for the applicant also says that the applicant was throughout on bail during the trial. Stop. It is nobody's case that he ever jumped any condition of bail or misused the privilege of bail. Stop. Paragraph. Learned advocate for the state opposes the prayer. Stop. She says that it cannot be said that the incident occurred on the heat of the moment. Stop. There is sufficient incriminating evidence against the applicant. Stop. Paragraph. We have perused the evidence on record and have considered the facts and circumstances of the case. Stop. It is not in dispute that the applicant was on bail throughout the trial. Stop. It is not the state's allegation that the applicant breached any condition of bail or misused the liberty in any manner. Stop. There is no certainty when the appeal will be heard. Stop. The appeal is of 2025. Stop. Numerous appeals filed much prior in point of time are yet to be heard. Stop. Paragraph. In view of the aforesaid, comma, we are inclined to allow this application.
It shall remain within the jurisdiction of
CJM Howrah, my lord. No. This is AJC Bose Garden.
Sombang is resident of?
Thakurpukur, Bortola, AJC Bose B Garden.
Oh.
My lord, Mr. Basu my lord,
Bose B Garden, police station AJC Bose B Garden.
my lord, CJM Howrah jurisdiction, my lord. CJM Howrah jurisdiction, my lord.
Howrah.
CJM No. It is my prayer that, my lord, he will stay within the jurisdiction of CJM Howrah.
Okay, right.
Picture.
Big matter. Item number 127.
Last occasion, these two appeals, Mr. S.N. Mukherjee has completed his submission.
Oh,
He is supposed to, my learned friend is supposed to respond.
Very well. Respond. Complete.
বারোটা পঁয়তাল্লিশে কি একটাই আছে দেখি
আবার একটা কিছু
ও 25 সরি আসতে হবে না
Sir, just for the benefit of your learned friends, roughly how long you will take?
My lord, today I'll not be able to finish, my lord.
Sheki kotha. Till recess you will argue.
My lord, till recess I may not finish because I have to show documents, my lord.
But at least till recess you will argue.
My lord, till
recess, enjoy your lunch.
আছে ওই আপনাদের notes of argument টা একটু my lord, may I start, my lord?
Yes.
Just to recapitulate, my lord, what is the case of the petitioner, my lord? My lord, the petitioner is an approved vendor of the railways. Now, here the respondent RDSO is an approving authorities of the vendors. These are important things, my lord. So there are process of approving the vendors.
Yes.
Now my client approves the vendors on behalf of all the railways. Now when I approve a vendor, different railways of different zones will procure material from the vendor, my lord. This is one of the crux of the case. So my first submission here is, my lord, that what test at the time of approving of the vendor is done, all those tests is not required, rather is not done at the time of procuring of the material. Now, my lord, at the time of approving of vendors, my lord, there are different tests which I'll take your lordships to those tests. One of the criteria at the time of, thank you, one of the qualification, I would rather say, my lord, and submit before your lordship, that one of the qualification is QAP. QAP is, my lord, stands for Quality Assurance Plan. Now, at the time of approving of a vendor, my lord, what happens? Different items are being taken up for approving a vendor. Now, my lord, here in this case, the petitioner is not a vendor of a particular item. If your lord, I'll take your lordship to that also, that he is a vendor of a complete assembly brake disc plate. He is a vendor, approved vendor of a complete assembly of brake disc. I correct myself, complete assembly of brake disc. Now, brake disc involves different components, out of which brake plate casting is one of the components in approval of brake disc assembly, my lord.
Brake disc casting.
My lord, brake disc casting, which your lordship will find later on, the name of that particular item was changed as friction plate, which is not disputed. The petitioners have also stated in their appeal that it was changed as a friction plate, my lord.
Yes.
So, at the time of approving of the vendor, there were different tests conducted, and different tests were conducted, my lord, by taking different components. Now, what happens in QAP? Whatever the test has been done on basis of the components, a prototype material is made, my lord, which my learned friend very well explained before this court, that in prior, my lord, the railway bridges, an angle used to come from London, a prototype used to come in India, and then used to make those materials. So here in this case, a prototype material is made out of one particular factory. Now, in making that prototype material, whatever the component has been used, that is written in the QAP. That is the source. That is the source. Because, my lord, your lordship will visualize, I make one Rafale aeroplane, fighter jet. Now, the engine, when the Rafale jet will be examined for its physical test, then the engine has been used from KE, America. Now we'll put that this engine in this prototype has been tried from the engine which has been put in from the America. Now later on, all of by your whims and wishes, if you change that, then what is the defect?
So you are saying the QAP will note the source of these components.
My lord, may I explain more to this, my lord? QAP is not only the source, it is entire quality assurance plan.
Also the source.
Also the source. And this is not by me. QAP is presented by them. I am the approving authority. Now, why do I require to approve it? It is my duty to see that the components they have used in the prototype, that particular component is mentioned or not. Now you do a test with taking a component of one particular make and have that done test from me, and thereafter you change the make. That is a violation of QAP, because the entire sanctity of the QAP goes, and the entire sanctity of the prototype also goes. Now, what is the importance of these prototypes test? That is evident from their letter itself. Now, I'll draw your lordship's attention where the problem actually cropped up from. If your lordship comes to page 154.
What?
154, my lord, of volume 2.
This prototype is also prepared by the vendor.
My lord, this is a test. At the time of approval of a vendor. My lord, I'll make everything clear before your lordship.
These are samples.
Samples, my lord.
Yeah.
I'm grateful, my lord. These are samples.
Page number?
Page number 154, my lord. Volume 2 of MAT 1491. They have referred to this MAT, my lord, 1491. My lord, 154, my lord.
Show cause notices.
Show cause notice, my lord. I'll draw your lordship's attention at the bottom of the show cause notice, my lord. May I place it, my lord? Only 2 lines, my lord, just to carry on the flow, my lord. From the above, it is evident that the firm has not sourced the item number 5 from Mrs. Kovis, Slovenia, as manufactured in approved QAP and not followed the approved QAP. Now, my lord, it is a collaboration, undisputed. But what my learned friend have tried to impress on the court, that this is Kovis, Slovenia, which is in Kovis, India. The firm is there, but there is one difference between that, my lord. Now, this brake plate casting, my lord, this was previously manufactured in Slovenia. Kovis DOO is one of the firms associated with JWL Kovis Indian part, my lord. So previously, when they were an approved vendors of this brake disc assembly, my lord, this item, brake disc casting, was being manufactured in Kovis, Slovenia's factory. Now, here the vendor is being approved, as well as the factory from which the material is being made. That is of very great significance. Why I say this, my lord? They have harped on this point that drawing is approved. So once a drawing is approved, irrelevant from where the source is being taken from. It has no logic, my lord. I can hand over the drawing here itself. Can this brake disc be made by a second party who doesn't have the proper factory, the proper machine, the proper warehouse, which I'll show that also why it is of significance. So here, my lord, the factory of Slovenia was the source at the time of approval of QAP. Now, my lord, the source is not required to be approved. I repeat, my lord, source is not required to be an approved vendor. But at the time of approval of the vendor, you have to mention it that here from I am taking this particular item. Because gathering all the components, you make that assembly. Now, thereafter, I make an prototype. I test those prototype. What tests are there? What are the significant tests? upon these prototype tests, and then the vendor is approved for making that particular item. So in QAP2, their source for brake disc casting was Slovenia. And in QAP3, after that QAP3 having been approved, and after going through that test, it is evident. Those tests, they have admitted that railway RDSO purposely made them undergo those tests which they were not required to go. But my lord, this is an afterthought, because I humbly submit, my lord, before your lordships, that if there were any trouble with regard to going through those tests at the time of approval of QAP3, because the source was being changed, then the complaint should have come at that instant itself. That look, I am not to undergo any other test. Now, my lord, I will take their reply to this show cause, which is of very great significance. This will give a clear picture to your lordship that what is a approval of a vendor, and after those approval of the vendors, railway of different zones procure material from these vendors. So very limited test at the time of procuring is done with regard to designs, drawings. I would rather submit that with regard to, my lord, physical appearance of the material, as well as whether these material which is being supplied is in terms of the QAP or not. They will see in the QAP what is the source, what is the dimension, what is what and all, where has it been made from. These inspection will be done, and then it will be procured from these vendors. But the vendor is being approved by RDSO. And RDSO is not the agency which is using this material. My lord, may I draw your lordship's attention to the next page, 155. And I would like to place this, my lord, thoroughly, because this gives a clear picture, my lord.
130.
Page 155, my lord. Next page to page 154, my lord, of the same volume, my lord. Yes. Dear sir, while letter under reference we received a show cause notice from your office. Therefore, we would like to provide the following clarification for your consideration. This is the reply to my show cause. As per our QAP, which was signed on 16th March 2023, we mentioned the details of the in-house manufactured component oblique sub-assemblies in section D, part 1. This list contains the brake plate number so and so. My lord, kindly mark this word, brake plate number so and so. It is not brake plate casting, it is brake plate. This was I was explaining before your lordship. Kindly mark this, my lord. It is brake plate drawing this. And its drawing number so and so as an in-house manufactured item. So brake plate, my lord, contains two drawings. This is one of the OZ number so and so. And the second one is KE 01012308, which my learned friends have been referring to. But the word, my lord, it is brake plate. It is not brake plate casting. This part is the same item which was also mentioned in part 3. Item number 6. That is the details of item sourced from other than RDSO approved items. So they submit here that this is the same part which has been mentioned in part 3 from other source other than RDSO approved source. I have already submitted before your lordship that all the items are not required to be approved items of the RDSO. It is only that you have to mention from which source you are taking, so that that source is freezed. At the time of making that prototype, the source has to be freezed. Because if the source is not freezed, my lord, then there is no use of making that prototype. If the formula is not freezed, my lord, thereafter, again, it will not be able to be made. Herewith, we are sharing the drawings number so and so for your kind reference. We are hopeful that the drawings will bring absolute clarity to this matter. So only 3 points which is in their show cause reply. My lord, may I be allowed to proceed further with this letter only? In the following paras, we would like to highlight about the various activities which were performed after our in-house foundry was successfully established and TOT completed. Now they want to mention what are the procedures were followed after their in-house, means in Indian part, my lord, Jabalpur. My lord, I will not trouble your lordship to read A, B, C. D I am reading, my lord. As per RDO specification, investment in foundry is not mandatory. However, with Make in India as our mission, we invested several times over the mandatory investment to achieve the highest degree of product quality, reliability, and on-time delivery of Indian Railways. My lord, first I would like to clear your lordship's doubt on Make in India, that they have been making in India, because they have been harping on this point right from the single bench, my lord. Make in India program, my lord, is actually to bring up materials to be produced in India. There is no doubt about it. But the Indian government is encouraging making India in a different way, my lord. What is the different way? Material which are being produced in India, the cost of the production may go higher. But Indian government in their government bodies are encouraging that if there is a Make in India product, even the product is of higher rates, you encourage a particular percentage of that material. Make in India policy nowhere says that you compromise on the quality and you make in India and risk the life of the entire citizen of the country. So my humble submission is, your lordship may not pay attention to this particular abbreviation used, my lord, Make in India. My lord, thereafter I will trouble your lordship to come from point G, my lord. Your lordship have got it, my lord? Point G. I'm grateful, my lord. Subsequently, after the above successful steps, my lord, may I pause, my lord? We are manufacturing the casting and we are in position to supply the same in-house represent. My lord, I'll place first F, my lord. Before we manufactured the casting and were in a position to supply the same in-house, representative from our technology partners, Covis, Slovenia, visited our factory, established our in-house casting process, provided all the required trainings to the Indian team, conducted necessary product qualification process, and then completed the transfer of technology process successfully. No doubt about it. But Covis Slovenia is not the approving authority. It can transfer the technology, it can help the Indian part to make a factory, but that factory will be approved after a prototype test from that factory. A material is made. And who is authorized to do it? It is the RDSO. It is not Covis Slovenia who will do this work. Second, my lord. Subsequently, after the above successful step, our representative visited your office and informed you about our foundry readiness in May 2023. Undisputed, my lord. After their factory is ready, they informed us. Anybody factory is ready, they will inform RDSO that I want to get my particular item approved as an approved vendor, so that there is a process. They have not bought on record those papers. I will not trouble your lordship with those papers. H, my lord, your office advised us to get a letter from our technology partners that the product is approved by the technology partners. Your office also suggested some changes in the QAP, which would happen only after getting the product approval letter from the technology partner. They had mentioned that this is my technology partner, so you have to get an approval from the technology partner before I inspect your factory. These are process, my lord. Our technology partner then sent a letter to your office on 18th May 2023, wherein they informed your office about not only the foundry readiness, but also that importation of the brake disc casting, my lord. Here the word comes again. Brake disc casting. Brake disc casting should be stopped and production done at Jabalpur. This is the case. Your office did not respond to the above letter, nor did it clarify about any prototyping requirement and type test requirement. My office did not inform them with regard to requirement of prototype requirement and type test requirement, and no objection to that. Probably this could be due to your demanding work schedule. Thereafter, my lord, we also submit revision 3 QAP to your office on 20th June 2023. Also did frequent follow-ups with your office both by telephone and by sending our representative physically to your office to obtain the approval of the revision 3 QAP.
Why were these revised from time to time?
My lord, I'm very grateful, my lord. This I will show that this question I put to myself when everything is there. Why from revision 2 to revision 3? There are on records what changes has come from revision 2 to revision 3. That I'll place later on, my lord. May I read this? And I'm grateful, my lord. Every time when we requested you to expedite the QAP approval, your office had mentioned the unavailability of the support staff due to excessive workload and priorities. So now they are requesting that do my prototype and type test. But every time I am telling that my support staffs are very busy. After 3 months wait, on 31st August 2023, we received a list of deficiency in our QAP, and we again submitted the revised QAP to your office on 27 September 2023. So there were certain deficiencies in their QAP submitted. We told them that may not have been technical deficiency. I'll not go into that, my lord. But I'm only showing the procedures. My lord, I will jump 3 points. Your lordship may kindly mark these last 2 points. Subsequently, we received another letter from your office to conduct the type test on 3rd January 2024. Again, this was a new requirement. But there was no objection to that, my lord. Thereafter, my lord, we would like to inform you that type test is an expensive and long time taking process subject to the availability of the test bench in the international lab. It is their admission that type test is a long testing procedure, my lord. And they want to supply railway with a material which has not gone under type test. And they say that drawing is approved, so source is not required to approve. I will bring a drawing of Rafale from France and I will make it in Calcutta. No factory is required, No machine is required. Nothing is required. Next, my lord, it is S. We accommodated the requirement and sent the brake disc to our technology partners, COVID Slovenia, for doing the type test. So, this particular component was sent to COVID Slovenia for type test. They completed the type test in the lab and submitted the report to your office on 8th March 2024. Subsequently, your office has approved the revision 3 QAP on 27th March 2024. This complete process took more than a year time, out of which more than 7 months time were consumed for multiple follow-ups and additional paperwork and 5 months for type test. 5 months for type test. What great significance is of type test? Next, my lord. In the following paras, we are highlighting the guidelines mentioned in the brake disc specialization of RDSO number so and so. Point B, my lord. Our peer companies purchase brake plate casting from their own suppliers, and the brake disc specification reference to does not specify any requirement about sourcing of the brake plate casting. I have submitted, my lord, that all the components are not required to be an approved RDSO vendor. But when you make a prototype, you have to mention the source, because that has to be freezed. According to that, we will every time keep checking whether the components used and the factory where it has been manufactured is the same or not. Because there is no other alternative to keep on checking the products for these particular tests. In our case, we have transferred the technology, set up the automatic molding lines, made patterns, set up the entire casting process. My lord, kindly mark this word also. Set up the entire casting process. So this casting process, particularly this casting process, was not being done in QAP 2 in India. It was being done in COVID Slovenia. And instituted the inspection testing process from our technology partners COVID Slovenia to produce the same quality product in India. Our technology partners has already confirmed your office about the IPR certification and successful technology transfer. Undisputedly, my lord, your technology partners may transfer anything to you, and the product may be identical to what your technology partner is producing. But I am the authority of approving that product. Because on my approval, the entire railway zone is procuring that material without going into these tests. There is no specification instruction in the brake disc specification number so and so that the firm shall repeat the complete product approval process, that is proto inspection and type test, if the firm establishes its own foundry. These are not in specifications. I have already submitted before your lordship that type test and prototype test is not for a particular item. It is for the entire item which you are assembling, which you are manufacturing, or you want to get yourself as a approved vendor. You just mentioned that I'm taking a fastener from Taparia. That's it. Because when I am approving that prototypes, I have noted down and freezed that the fasteners used in this brake disc is from Taparia. At least that has to be maintained, because then the quality and the sanctity of this department goes, my lord. Today, my lord, if your lordship does not allow the order of the writ petition, then the entire sanctity of this DSO goes. Then anybody, the railway departments which are purchasing the product, it is what test they will do, and upon then they will put this brake disc. If accident happens, then only we'll come to tell them that, see, there is a damage, accident has happened. Now we will terminate you, will downgrade you. Before that, we cannot have any measuring process to avoid this accident. I repeat, my lord, this RDSO is to minimize the accident and to stop accidents, to maintain the quality of the product. It is their duty to keep eye on the quality of the product. My lord, E. As a tender condition, 50% local content is mandatory. Brake plate casting is the highest value item in the brake disc assembly. Therefore, without localizing this part, meeting the minimum local contents criteria is not possible. I dispute to this, my lord. In the vendor approval process, there is no such mandatory. Otherwise, Covid Slovenia would not have been approved as a vendor. Now, preferences are given, my lord. I submitted before your lordship that as per Make in India, if you are making something in India, if the cost even goes up, government gives a certain reservation to the items which are being made in India. So if your 50% contents is of India, then you will be put in some particular category higher to that somebody who is taking material from outside. This advantage you enjoy. But for approving your vendor, approval of vendor, you do not require, because case is before your lordship. Brake plate casting was being imported from Covid Slovenia at the time of QAP2. So this statement, my lord, is just a jungle up, my lord. During your visit for capacity cum capability assessment, our foundry was at the final stage of commissioning. We have accomplished this milestone by March 2023. Therefore, in QAP revision 2, KE so-and-so appears both in the, there is no connection between this paragraph. When I went for inspection, their capacity cum capability assessment. This is also very important at the time of approval of a vendor. Their capacity of producing the material and their capabilities, how they are keeping the material, whether there will be any crack to that material. There are very hair cracks, my lord, in cast iron product. So these procedures were going on when I had gone for an inspection. And it is for those period, they want their material to be inducted in the railways. It took us almost 5 years for us to set up the complete foundry. Our technology partners informed your office about our in-house foundry readiness on May 2023. Unfortunately, your office did not respond anything to this letter and did not mention about the prototype inspection and type test requirements. My lord, kindly again mark, I would humbly submit, again mark this word, my lord. Probably this was due to your demanding work schedule. So here they do not deny that there is no requirement of this particular things.
Hey.
My lord, may I pause for a minute, my lord?
Monday, same time.
Grateful.
Mr. Singh,
My lord.
I'm a learned advocate representing the respondents.
My lord, I'm led by Mr. Pinaki Chakraborty, my lord.
Yes, we see that. Today you argued.
I'm so grateful.
Uh, begins argument on behalf of the appellant, begins his argument, but does not conclude. Paragraph will list the matter once again. Monday date the mark 12:30 p.m.
I'm so grateful. Extremely grateful, my lord.
We really are at a loss.
No, well, I'm
We'll
on
first take up original side.
my lord. After that, you will lordship will return.
If time permits, we'll take up.
My lord.
There are not too many matters in the original side.
My lord.
So let us see. From next week, what we'll do, we'll take up appeals, we'll fix the time for appeals. Otherwise, it becomes impossible.
Item 63.
Actually, I'm being led by my senior. I'm praying for only 1 day's accommodation.
Not Thursday.
Thursday, my lord.
Item 63 and 64, these are connected appeals. Now, I have instructions to appear for the victim on behalf of Calcutta High Court Legal Services Committee. The difficulty is, I find that the plan has been filed for appeal, but the copy has not been served on me.
Give him a copy, sir.
Then can it be taken on
Thursday,
I
Friday,
will be requiring a day's timer to go through the job.
then Thursday.
Thursday.
He'll give it to you today. Give it to him today. Lekho একটা accommodation একসঙ্গে করবে 63, 64. You are not in 64.
Only
64, there's no CRAN application.
Oh, I see. Accommodation is paid for on behalf of the appellant in CRA DB 212 of 2025, paragraph, as requested by learned State Council, comma, let these matters be listed again on Thursday date now, under the same heading, paragraph, learned advocate for the appellant in CRA DB 212 of 2025 shall make available a copy of the application for suspension of sentence that has been filed by the appellant to learned advocate appearing for the victim in course of the day.
With 66 and 67.
But 65, I am for the petition. There is no CRAN application. 67 is CRAN 2. 65, I am for the state along public prosecutor.
Lordship, in this conviction under NDPS Act, sentence for 10 years. From me, alleged seizure is 31 kg, 668 grams of gaja in September, and in July, from two other accused, 313 kg of gaja was recovered. I am in custody for more than 8 years, 2 months out of 10 years.
Pre-conviction.
Pre-conviction. If your lordship sees the tenure of the independent witness, as per independent
antecedents,
no. As no antecedent recorded in the judgment, no antecedent. As per independent witness, I am just reading. I was also told by police that person Kartik Kundu had been detained with gaja and cash. Kartik Kundu was sitting inside police van. That is the independent seizure witness.
PW8.
What is your submission?
Only PW8, independent witness stated that the recovery, regarding the recovery, 313 kg, 188 grams of gaja recovered from the 4 person.
313?
No, not from me. 4 person. Subsequently, my lord, the statement of the co-accused, 31 kg, 668 grams of gaja recovered from the appellant. Regarding 65. But out of 10 years, 8 years, 2 months already custody, my lord.
So you are paying for bail. You are paying for bail. You are not there.
I have to.
So I shall record your submission that
From my possession, after 2 months, recovery is 31 kg.
PW8.
ও প্রেসিডেন্ট তৈরি করে নিতে চাই যাতে ও ওখানে গিয়ে বলে ও বেলটা পাবে
No.
হ্যাঁ
এটা 65 এর হচ্ছে the appellant oblique applicant was convicted under section 20 ব্র্যাকেটে বি ছোট বি আবার ব্র্যাকেটে আই আবার ব্র্যাকেটে ক্যাপিটাল সি oblique 29 sections করবে তাহলে 29 of the NDPS Act by a judgment and order dated April 10, 2025, passed by the learned additional sessions judge, judge, special court, bracket NDPS Act, bracket close, 12th court, Alipur, South 24 Parganas, in ST 05, bracket 02, bracket close, 20/ST number 02, bracket 08, bracket close 2018, SC 06, bracket 07, bracket close 2018, NDPS -89 of 2017. Stop. The appellant was sentenced to suffer rigorous imprisonment for 10 years. Paragraph. The applicant says that he has already spent 8 years,
2 months.
2 months
Paper book already read.
in custody. Stop. All throughout the trial, he was in custody. Stop. The sole, there are several loopholes in the prosecution case. Stop. The sole independent witness, sole independent Caesar witness.
Caesar witness, because there are
PW
8.
8.
Regarding this appellant only, there are several.
PW 8. The sole independent Caesar witness as regards this applicant, being PW 8, has deposed that at the time of Caesar, he saw the appellant sitting in the police van. Stop. The applicant therefore says that he has a fair chance of success in the appeal. Stop. He should be granted bail pending disposal of the appeal. Paragraph. Opposing the prayer, learned State Counsel says that there is sufficient incriminating evidence against the applicant. Stop. Commercial quantity of contraband item is involved. Stop. Paper book is ready. Stop. The appeal may be heard out. Stop. The bail application should be dismissed. Paragraph. We have considered the facts and circumstances of the case. Stop. We see that the applicant has substantially served out the sentence. Stop. More importantly, there is no certainty that the appeal will be heard on an early date, since appeals filed much prior in point of time are yet to be heard. Stop. Paragraph. On an overall assessment of the facts and circumstances of the case, and that the applicant has already been in custody for 8 years, 2 months, and keeping in mind a citizen's right to speedy justice, which in this case may not be possible because of pendency of old appeals, we allow the applicant's prayer for suspension of sentence.
He shall meet the IC Thantala PS twice in a month and shall not leave district Nadia, excepting for the purpose of
PJM Alipur.
CJM Alipur. 67.
37 lordship appearing for the state lordship.
Who is for the applicant? 67.
67.
67.
Computation of, along with remission, I have given to your lordship.
So remission is subject to good conduct. Remission is available.
No.
He is saying no.
This is also NDPS case.
There is no revision. 32
Then
Same accused.
32 there is no revision.
Same case, another accused, 8 years, 3 months.
Without remission.
Remission, they are saying no remission.
So without remission, 8 years, 3 months. The same order হবে তো। না ওইটা খালি হবে না, PW8 that soul
In this case, my lord, PW 5 and 6. The independent witness
65
not
60 একটা হচ্ছে
above the prosecutor.
হ্যাঁ কিন্তু লোকটা তো এক নয়।
না লোক একদম
হ্যাঁ ওই লাইনটা খালি দেবে না যে সোল
how much recovered
Seizure and recovery of 313 kilogram of gaja.
313 kilogram, 108 grams.
108 grams, lordship, of gaja from the joint possession of this appellant and one Hori Prasad Mojumdar, who has not filed any CRAN application, lordship.
joint position
Joint possession.
Recovery for 4%. Recover for 4%.
31 কেজি
যাই হোক তোমার
313 kgs.
ওই লাইনটা সেন্টেন্সটা খালি কেটে দেবে যে the sole independent seizure witness বলে যেটা বলেছিলাম as regards this applicant PW. No, we are deleting that sentence from this order. 8 বছর 3 মাস 8 year 3 months ওটা 2 months ছিল এটা 8 year 3 months কি একই অর্ডার শিটে থাকবে তো পরপর
এই আগেরটা কোথায়
cancel করে তাহলে দুটো ক্রাইম ডিসপোজড অফ হয়ে গেল when should the appeals be paper book ready
Yes, lordship, has been ready, lordship.
4 weeks since or 3 weeks since or January monthly list let the three appeals appear under the appropriate heading in the monthly list of January 2027
পুলিশ স্টেশন পুলিশ স্টেশনটা নিউ বাগদা হবে নিউ বাগদা আর ডিস্ট্রিক্ট হবে নর্থ 24 পরগনা আগেরটা এইটা
মেয়েটার বয়স কত ছিল?
For the appellant, my lord.
was the victim's representative notice served
State was directed to serve upon the victim, my lord. Mr. Chatterjee, Sujan Chatterjee was appearing. Let it be not today, my lord. I believe he has
We're
got
praying
some.
for not today, ma'am.
not today
I think today possible, today possible matter.
not possibly not
Tomorrow, my lord.
I'm praying for a day's accommodation.
Your lordship, in that event, my lord, day after tomorrow may be fixed.
sorry
Day after tomorrow may be fixed, your lordship.
on the request made by learned advocate for the appellant, let this matter stand adjourned and be listed again on Thursday date though.
Statement.
70, my lord, I am praying for not today.
On the prayer, করে দাও অপূর্ব, made on behalf of the appellant, let this matter stand adjourned for the day.
Lord, 71, I am for the appellant. My lord, 4 persons were convicted, my lord, on charges of 300-234. My lord, out of those 4, 3 preferred a separate appeal. My lord, and those 3 have been granted, my lord, the benefit of suspension of sentence by a coordinate division bench. I have annexed that order at page 60 of my lord suspension application CRAN 1.
Those 3 are male.
Same footing, my lord, same footing as
This applicant is male or female?
No,
Male.
they are also male, I am also male. 4
name is
male persons were convicted. Yes, my lord, that was the first question I also asked when the brief had come to me. But he's a man, he's not a woman.
But page 60 is the order of bail.
And I'm on the same footing with those 3.
Not same footing, but I would just say they have the finding is that cause of death may be accidental.
That's the autopsy surgeon's finding.
Page 60.
60 of the CRAN, my lord, of the suspension application.
But I do not find it was accidental. PM doctors PW
No, no.
21.
PW 21, yes, it's from the judgment itself, it reflects, my lord. Page 32, you see running page 32, top first two lines. See page 32, first two lines.
Such type of injury may be caused if a person trying to board the train fall down.
So-
Maybe.
So, my lord,
But my lord, the cause of death is just before the first page 31.
but they have not challenged that order, my lord.
My lord, that I said. We have not challenged, but the cause of death was not accidental. The allegation is there were 5 eyewitnesses to that incident.
Same footing as this person.
We were on bail during trial.
Yes, yes.
That
On
is
bail
also a
during
factor.
trial.
But there's 5 eyewitnesses to this incident. They were on the train. There was a commotion. There was a fighting. They came out of the train, and then these 4 persons jumped. But we have not challenged this.
Then why should Article 14?
Yes, I'm deeply obliged.
Issue. Niche কি করেছে?
ওদের গায়ে চাপিয়ে দাও।
হ্যাঁ। The applicant, oblique appellant, and 3 other persons were convicted under section 302/34 of the IPC, life
imprisonment,
and were sentenced to suffer life imprisonment. Stop. Paragraph. Mr. Chatterjee, learned senior advocate appearing for the applicant, says that the other 3 convicts filed an appeal, a combined appeal, and on their application made in that appeal, they have been granted the benefit of suspension of sentence.
My lords.
Stop. He draws to our attention the relevant order dated October 9, 2025, passed by a coordinate bench in Pran 1 of 2025, filed in CRA DB 339 of 2025. Stop. Learned counsel says that the applicant stands on the same footing as the other 3 convicts. Stop. That apart, there are sufficient loopholes in the prosecution case, and the applicant has a very high likelihood of succeeding in the appeal. High chance of succeeding in the appeal. So, hence, he also prays for suspension of sentence. Paragraph. Opposing the prayer vehemently, learned state counsel says that this applicant does not exactly stand on the same footing as the strains. That though this applicant may stand on the same footing as the other 3 convicts, there are 5 eyewitnesses to the incident of murder. Stop. It is of murder.
The PM doctor's finding, which was recorded as accidental, is not accidental. What I find from the deposition.
The Stop. That apart, there is sufficient incriminating evidence which would support the conviction. Stop. Hence, bail should not be granted. Paragraph. We see prima facie that this applicant is similarly circumstanced as the other 3 convicts who have been granted bail pending disposal of the appeal. Stop. Hence, stop. It is also not in dispute that the state has not challenged the order of the coordinate bench, whereby the other 3 convicts have been granted bail. Stop. Paragraph. Hence, on the ground of parity, we suspend the sentence of the applicant and grant him bail. Pending disposal of the appeal.
I'm deeply. Deep.
মিট করবে
যা কন্ডিশন ওরা দিয়েছে আমরা ওটাই
ওইটা দেখে দাও
ওরা যা কন্ডিশন
সেম কন্ডিশন
in the other one.
কিন্তু আমাদের যেগুলো এক্সট্রা থাকে সেগুলো দিয়ে দেবে
Deeply.
Satisfaction of
CJM, my lord, it's recorded in there. CJM, my lord, Krishnanagar, Nodia. CJM Krishnanagar, Nodia. I'm deep.
72.
For the appellant, my lord, I'm appearing for the NIA in this matter, my lord. My lord, this is, my lord, under section, my lord, the provisions of UAP Act.
UP Act, my lord,
And my lord,
appeal, bail appeal, my lord, and
and-
put the matter on next week. Mr. Kabir is appearing in this matter when he come on next week, my
Yes, they have a right of appeal.
yes, no, yes, that's true, my lord.
Okay, so
But
we'll admit the appeal and hear the appeal.
Well,
No, no,
kindly
my lord.
fix the matter on next week, my lord.
Just, my lord,
My lord.
appeal, my lord. But he is not convicted, my lord. My lord, just, my lord, as an appeal, my lord, 21(3), my lord. That is an appeal against the order of rejection of bail. Now trial has commenced, my lord.
Oh, this is an appeal
Yes,
against
yes, my lord.
ordinary
Since, my lord, NIA, my
bail.
lord, Act, my lord, as per NIA Act, my lord, it's an appellable order. Any order, appellable order, my lord. So, my lord, I am, my lord, praying before Lordship, my lord, 3 weeks time, my lord, to give our written response.
2 weeks,
Because, my lord,
Mr.
the trial is now, my lord, 2 weeks, my lord, very possible, my lord. Now, because of some change of situation, my lord,
No,
all the
Mr.
officers.
Maiti, it has to be possible. We will not grant you. Your client has to pull up the socks. Just because they are NIA, they can't say
No, my
we'll
lord.
take more time.
My lord, difficulty is this, my lord, now in this situation, my lord, most of the officers, my lord, out of stations, my lord. Most of the officers out of stations, my
Oh,
lord.
achha, achha.
Because of some
national.
My lord. Most of the officers. Otherwise,
Very
my lord,
well, 3 weeks.
this is the difficulty, my lord. And my lord, apart from that, my lord, 3 annexures, my lord, we have not been supplied, my lord. My brief is incomplete, my lord.
Okay, I will supply, my lord.
Supply.
Did my learned friend supply this?
This appeal is directed against an order of the NIA court rejecting the appellant's prayer for bail.
And it was earlier rejected, my lord, on 13th August.
On
Stop. The appeal is admitted.
Yeah.
Stop. Paragraph. As requested by Mr. Maiti, learned senior counsel representing Union of India,
NIA, my lord.
Union of India is the party.
Yes, my lord. That will be there, my lord, but we appear for
Bracket
the
Union of India, bracket NIA. Comma. Let this matter be listed after 3 weeks. Stop. Date 3 weeks date bracket. Stop. In the meantime, the
written response, my lord.
respondent will be at liberty to file its written response to the appeal petition. There's a petition.
appellant.
Appeal petition. Stop. Paragraph. Mr. Maiti says that some annexures to the appeal petition are missing.
Yes.
Stop. Learned advocate for the appellant says that he will ensure that copies of such annexures are made available to the advocate on record for the respondents by tomorrow. তারিখটা কত? 9th December.
Lord, with regard to this item, my lord, Lord, I beseech your lordship, my lord, kindly take up this matter tomorrow, my lord. Because Mr. Bhaskar Bhattacharya, my lord, one of his relations, my lord, expired morning, my lord.
Mr. Bhaskar Bhattacharya?
Bhaskar Banerjee, my lord. Lord, he has not come to court, my lord.
Very well.
Only my lord, tomorrow, my lord. Tomorrow. Tomorrow, my lord.
Not today, not.
My only fear, my lord, I'll tell you, lordship.
No, no, no. I'll do it.
No, no, Mr. Afner Kothana. He'll again go down the list.
It won't go down.
No, no,
it will be where
it will
it is.
remain in its position. Virtually.
Won't go down.
If it goes down, can be mentioned. If it goes down, can be mentioned.
If it goes down from where it is, you may mention.
It's a very tricky situation. Very well. My lord, I'll come back tomorrow. So far as the next one is concerned. 74.
But so far, next one is concerned, my lord. My learned friend is appearing, my lord. My lord, I may be granted, my lord, at least 10 days time, my
No,
lord.
no, who? You are appearing the next one?
For the first time, my lord, appearing, my lord.
No, for the second time. Last time also it appeared.
No,
And he
that
had
is, my
said
lord, that has not been heard, my lord.
No, no, but
Because
it
we
was
want
said
to
that-
use, Milord, now, Milord, I ask for Milord time, Milord. Now, Milord, 10 days time will be sufficient, Milord.
Why time?
To file a written response, Milord.
Let's see.
Only this much.
Parity.
But that I will satisfy, Milord, whether it will be
The
parity
High
or not,
Court
Milord.
has
At the time.
struck down UAP in this matter.
No, no, Milord. Trial is going on under the UAP Act.
I can't believe after the High Court has struck down UAP.
That will be considered by your
Busy in
lordship.
national interest.
That will be, Milord, considered at the time of hearing. Only
This
about
is-
10 days time, Milord.
Thankfully, my
Only
lord,
fix
this
up
is
a
not
matter
national
after 10
interest.
days, Milord.
May I just indicate to your lordship one thing? I will not stand in the way. This is thankfully not national interest. This honorable court, my lord, has indicated that this is not national interest. That is the order. So let him not say that this is national interest.
You're applying
will
for
argue on
bail
this
before us or appeal
Whether-
from rejection order?
Bail, but in terms of section 21, I have to file an appeal because my lower court rejected.
Every Milord
appeal
order,
against
Milord,
order.
interlocutory.
It's an appeal against order, but technically these are
Every
not
order,
bails.
every order, Milord, is an appellate order before the division.
Appeal, but these are bails.
That's why it's an appeal.
Dekho, the appellant's prayer for bail was rejected by the NIA court. Stop. The appellant has come up against such order by way of this application. Paragraph, Mr. Maiti, from a learned counsel representing NIA, seeks 10 days time to file written response. Stop. Let that be done with advance copy to learned advocate on record for the applicant. Paragraph lists the matter. 10 days মানে গুনতে শুরু করা আছে কত তারিখ? 18 28th.
28th?
Yes.
28th is 28th.
28.
Whenever. Absolutely. 28th.
November 28.
Doctor হতে হবে।
Top.
My job is to ask. It's a prayer that we always make. Not everything has to be acceded to.
Correct.
Grateful, man.
You're a wise man.
My lord, I just charge money. That's all. Grateful, man. Grateful. 75.
Your Lordship, I am appearing on behalf of the appellant. Generally, the learned counsel of the appellant could not able to has left the court due to some emergency. So therefore, kindly make it not today.
On the prayer, dekho, politics called hai na. On the prayer made on behalf of the appellant, oblique applicant. Let this matter stand adjourned for the day. Recorded হয়ে গেল।
Lordship, in this matter, I am appearing on behalf of the appellant. And this is the relaxation. I am an old lady from Bijnor, UP, and I have to come every month to Barasat in terms of the order passed by the Honorable Court dated 10th January 2024. I duly complied the order. I have already annexed. And the latest development didn't take to.
Orderটা কত জিনিস 3 years.
She is an old lady, Lordship, so kindly give some relief. Each and every date she has to come, and she has already complied the order. And she is not the principal accused in this case.
Trafficking.
Lordship.
Then
Conditions have not been complied, Lordship.
No.
Grant 3, if your Lordship has, there was a direction to report to the learned Chief Judicial Magistrate.
Yes, every day.
Once a month.
Grand 3.
Grant 3, I have, Lordship.
Grand 1. What is the name? Chitra Sharma.
Chitra Sharma, Lordship. Grant 3.
Grand 1, 10 January 24. Order.
Order.
Lordship, 10 January 24, Lordship. There's a Grant 3 served for relaxation.
Grand 3 is for. Yes, Grand 3 is for Grand 5.
5 of it.
They have also filed a Grant 3 for relaxation.
You had filed the Grand 3 earlier.
Lordship, Grant 3 has been filed and the annexures in Grant 3 do not pertain to this petitioner. Showing
It may be mistakenly here, but only
No, but
One
sir,
relaxation
you
has
do
been.
this, file a report as to whether she has been complying with the conditions of bail. She was granted bail by order dated 10th of January 24 by a coordinate bench on primarily the condition that she will report to the magistrate once in a month till disposal of the appeal. Has she been doing that?
The crime 3 relaxation which has been served on us, they are annexures showing that attending the police station at Mahestala.
No.
Which is not, this is the crime 3 which has
Lordship,
been served
I have just given.
crime 3 has been served upon the state.
I have just given
What crime 3? We do not have any crime 3 here.
to the magistrate.
And 5.
Lordship, I have annexed to the magistrate.
Where is your crime 3?
Crime 3 has been, because of which their number has been given.
The crime 3 is not by this applicant.
This applicant, the name is Chitra Sharma.
No.
Crime 3 is by
Rahul Kumar Jadhav.
Sushil Sharma.
Yes.
Chitra Sharma.
Sushil Sharma.
For me, Lordship, the first title is showing Chitra Sharma. They have made some mistake in the file.
Chitra Sharma and Sushil Sharma might have filed a combined appeal. I don't know.
They might have a combined appeal. Crime 3, the brief served on the state lordship shows Chitra Sharma is the applicant.
Forget about crime 3. Crime 3 is not about Chitra Sharma. We are on crime 5 now.
And crime 5, you have annexed the attendance report from Mahestala PS.
And that is the documents that were annexed in crime 3, and because of which I was saying that she is not complied, lordship.
So
I have got the report
I
from
have
Mahestala
given
PS
the
also.
magistrate's order just now.
I have got a report from the Mahestala PS. It is not even this petitioner who has gone to the Mahestala PS. It's some different individual, not Chitra Sharma.
So you better file a report, sir.
Lordship, this is a report from Mahestala PS
as
regarding the annexure of attending the Mahestala PS. The police station has informed that it is not this applicant who has attended.
So you are not complying with the direction. So we are rejecting your prayer.
I have given lordship.
Who was from your sir?
I have given the lordship entire order sheet of the learned court below. Just now. Has occurred by mistake. Entire order sheet is there, lordship.
All you have annexed is your attendance to the police station.
Lordship, I have also given the entire.
Now, right now.
In crime.
একখানা দিয়েছে চিত্রা শর্মা You please go through this.
Sir, you are not following us. This report is useless, what you have filed today. We want to know whether she has reported to the magistrate every month.
That they have not annexed. They have annexed these GD entries.
Now they have handed up. You go through it, also make independent inquiry and file a report. Again.
May I suggest, since it's the Chief Judicial Magistrate's office, would your lordship call for a report from the Chief Judicial Magistrate as regarding this? Because the investigating officer of the inquiry.
What is your problem, sir?
I will call for it.
The applicant, Chitra Sharma, was granted bail pending disposal of the appeal, by an order dated January 10, 2024, passed by a coordinate bench in CRAN 1 of 2023. CRAN 1 of 2023 filed in CRA bracketed DB 191 of 2022. Paragraph. Now, the Chitra Sharma's sentence was suspended inter alia on the condition that she shall report to the learned CJM, North 24 Parganas at Barasat once in a month till the disposal of the appeal. Paragraph. The applicant has now prayed for relaxation of that condition. She says that what is her age?
60 years old.
60 is nothing.
It's not lordship.
She says that she is 60 years of age. So it is very difficult for her to travel to Kolkata every month. Kolkata from
Bijnor.
Okay,
Bijnor, Western UP, adjacent to Delhi. Bijnor.
She shall stay here.
No.
Why not?
every month.
They're modifying. We will modify.
Stop. She says that she has been adhering to the conditions of bail scrupulously. Report the paragraph. Learned. Now, the state shall file a report after making requisite inquiry as to whether or not the applicant has been reporting to the learned Chief Judicial Magistrate, North 24 Parganas, at Barashat. Stop. Paragraph. List this matter once again next Tuesday. Date ta diye daao.
$77 with $78.
My lord, I am for the appellant led by Mr. Jantanan Chatterjee. My lord, this is a relaxation of condition of
CBI counsel.
Lord, Mr. Omajit Dey is appearing on behalf of
he's
this
not
CBI,
here.
my lord. He informed me that he is engaged in another courtroom, my lord.
So what can be done right now? Me, CBI counsel.
You are for the applicant.
Yes, my lord.
Relaxation of bail.
Yes, my lord.
Where is Mr. Deshi? He is not here. If you can get him, we'll take it up.
Pass over, my lord.
We can pass it over. We can make it not today, whatever you like.
My lord, make it not today, my lord.
Not today.
Great.
She dictates 7. Where is Mr. Shubish Shannal? You are appearing? Very good. No, last time you did not appear.
No.
Very good.
And for the
an opportunity got to appear.
Well, there are two limbs of the matter. One is why the impugned action by the respondent is bad, and second is why the order appealed from is bad. So, first lordship takes up the order, my lord, which is the paper book or state petition page 308.
The learned judge has granted you liberty to approach the grievance redressal officer and has said that until this controversy is decided by the grievance redressal officer, the past bills will not be given effect to.
That part I am accepting.
You say that grievance redressal officer has no jurisdiction.
Jurisdiction, because first let me say what is the dispute. Only then I can point out from the regulations whether he has jurisdiction or not. That's why I say Lordship takes up the order.
Yes, order is before us.
Lordship. Lordship, take the first paragraph. The petitioners were consumers under the respondent number 1. I am no longer a consumer. And a grievance redressal officer has jurisdiction only to adjudicate disputes between the intending consumer and existing consumer and the licensee.
If the power company, just trying to understand, if the power company wrongfully disconnects your electric,
Lordship.
according to you wrongfully disconnects the power supply, you cease to become a consumer.
My lord, by legal fiction, I don't, because I have a right to approach certain forums and I don't become an ex-consumer automatically. It's like tenancy, even if determined.
In this case, how did you cease to become a consumer?
Because logically takes up the paragraph at internal page 3.
Yes.
Second paragraph. Internal page 3, second paragraph. It is undisputed that the electricity line has remained disconnected since January 31, 2025, and that the petitioner have been availing electricity from another licensing company thereafter.
So the power company disconnected your supply.
Their case is they have not disconnected, I have disconnected.
Their case is they have not disconnected.
In fact, Lordship, take up the submission of Mr. Subish Hannal at internal page 2. Mr. Subish Hannal, Lordship got it? Let a senior counsel appearing for respondent number 1 draws the court's attention to regulation 4.4.1, I will show just now, of the supply code. Supply code meaning supply code regulations framed by West Bengal Electricity Regulatory Commission, issued by the West Bengal Electricity Regulatory Commission. He submits the petitioner had no authority in law to unilaterally disconnect the electricity supply. It is argued that the disconnection should have been effected only by the licensing company after clearance of outstanding dues by the petitioner. Consequently, he contends that the demand charges raised post disconnection are legally justified. That is the dispute, crux of the dispute, whether a licensee can raise bills upon me after disconnection. Still today, he is raising bills on me. Under what provision of law? He said that he contains the demand charges raised post disconnection are legally justified. So this is the point, my lord, which licensee has to answer. This is one part. And secondly, little bit facts are more facts are necessary. Logically, first take up the stay petition, volume 1, at page 10. Stay petition, Lordship, with you, Lordship. Page 10.
Prayers.
What I am seeking now, mother. What happened, my lord? The line has been disconnected. I am taking electricity power from West Bengal State Electricity Distribution Company Limited, but they are not removing their apparatus, which is lying in my factory, and they are raising bills upon me. Their apparatus they can keep wherever they like. Why my objection is, after disconnection, they cannot raise any bills upon me. And this dispute, my lord, with utmost respect, grievance redressal officer cannot decide, and whether the apparatus are to be removed
because they are occupying my space. I'm entitled to rent for that if they want to keep it. They are welcome to keep it. They can keep wherever they like their apparatus. But if they keep in my factory, they have to pay rent for that.
And this
And-
27 crore you have claimed on account of rent. Prayer C.
Prayer C, yes, 27 crores I have paid, not rent. This is electricity excess I have paid to them.
So how units are being calculated? If the disconnection was done, how the units are being calculated?
It should be zero. They are raising demand charges. Then, Lordship can see, I am praying interim as an interim order that West Bengal Electricity Regulatory Commission, because the amounts are due under the orders of Electricity Commission, be directed to calculate the amount, because court cannot, obviously. Let WBRC calculate what is the amount due to me, and then Lordship can direct for refund. And he should be directed to remove his apparatus. These are my prayers, 3 limbs. 1, after disconnection, they cannot raise any bills. 2, a huge sum of rupees.
Tell us one thing. A learned single judge decided the writ petition after on affidavit.
No, my lord. On the first day.
You should file an affidavit, Mr. Chatterjee.
There. Here.
Your stand is not on affidavit.
Yes. You have filed an affidavit here.
Before the learned single judge, your client did not file any affidavit because the learned judge did not direct filing of affidavit. It is better that you file an affidavit disclosing your stand.
Yes, I will do that.
Serious allegations have been made that there is no supply, you are raising bills merrily, not removing your apparatus.
Under the
These
agreement.
are factual allegations.
Yes, under the agreement, I will not remove the apparatus until my dues are paid. That's the agreement I had with him.
Very good.
How you are raising? How we are raising current bills?
No, these are not
basis
current
of units. Which units?
No, there was no disconnection. Disconnection has a separate connotation in the agreement itself.
Very well. This appeal is directed against a judgment and order dated September 22, 2025, whereby a learned judge of this court disposed of WPA 20955 of 2025, being a writ petition filed by the appellant's hearing. Stop. Paragraph. Learned. Now, in effect, the learned single judge referred the disputes between the parties to the grievance redressal officer. Stop. Paragraph. Mr. Shorkar, learned senior counsel appearing for the appellants, says that although admittedly electric connection to the appellant's factory remains disconnected, electric supply to the appellant's factory by the respondents remains suspended since January 31, 2025, the respondents are carrying on, respondents are merrily raising bills on the appellants every month. Stop. Further, in spite of repeated requests, the respondents are not removing their apparatus from the premises of the appellants. Stop. There has also been huge overpayment by the appellants to the respondents. Stop. Accordingly, certain prayers have been made in the stay petition. Paragraph, we notice that the learned single judge disposed of the writ petition without calling for affidavits. Stop. Therefore, the stand of India Power Corporation Limited, being the principal respondent, is not on record. Stop. Paragraph, let the respondent number 1 file an affidavit in opposition to the stay petition within 10 days, 10 days, 10 days.
Give us 2 weeks.
2 weeks, 2 weeks from date. Tariq diye debe bracket e, stop. Reply thereto, comma, if any,
1 week.
comma, be filed within a week thereafter. Abar Tariq diye dao. Paragraph, list the matter under the appropriate heading on the following working day. সেটা তারিখ কত হবে? হ্যাঁ? 10th. 10th December.
10 December. 10 December.
Well, only one prayer, my lord, that let WBRC calculate the refund, because somebody has to calculate the refund.
Lord,
In the meantime.
After hearing. Not now.
Here I join issue.
Not now. We're not. Have you made that commission a party?
No, my lord. No. As a referee, special referee, because they are the ultimate on electricity.
Let us hear you on affidavit and then.
Well, may I file the affidavit of service?
Affidavit of service to Gorate niye na.
Item 80.
I'm the respondent number 8. This was, my lord, in respect of housing society, where, my lord, we had insufficient number of car parking spaces. So we bought the adjoining land and, my lord, we allotted car parking spaces, the remaining car parking spaces on the adjoining land. But we've been asked, my lord, formation of a new society was prevented because, my lord, objection of 2 persons who said that the 2 plots should be amalgamated first, which is, my lord, completely incorrect.
Chaudhuri, the writ petition is still pending.
Yes, but, my lord, I was before your lordship.
Maintenance of the property. You have been directed to continue to maintain the property.
Yes.
What if they all pay maintenance charges?
My lord, I have no objection.
We'll clarify that. If they don't pay, you don't maintain.
Already clarified by the Honorable Single.
You will further clarify. And then go back before the learned single judge, have the writ petition disposed of.
May I just point out one thing?
Who are you?
Your lordship had said that not a single one single person doesn't.
That
pay,
cannot.
You don't.
That cannot be, because the statutory obligation. I'll show, my lord. The statute says, the RERA Act, that till formation of the association, the duty of the developer is to maintain the society, subject to payment. But it doesn't say.
Banerjee, if the statute imposes an obligation, he will have to comply with it.
My lord. And if in case of non-payment, my lord, there are consequences. He will not maintain that quarter. He will not provide services. But the entire, my lord, there's not a single society in the
What
state,
about the common areas?
Now, my lord, kindly consider this, my lord. The society has, my lord, several flats. Now, if the majority pay, but some flats do not pay, they cannot stop the services.
You can't stop them from using the staircases.
The water can be they can stop the water and the collection of garbage. Those services can be stopped. Kindly consider what happened, my lord, in this case, my lord. The Honorable Single Bench passed an interim order because they wanted to form the association by, my lord, taking some property which is not part of the sanction plan or the completion plan. Our objection was that unless that is part of the sanction plan, you cannot form the association with an alien property. The competent authority favor.
Incorrect the objection is.
It is,
I have
not. It is not,
purchased the
because
property. It's
it has to be
adjoining
part of the
property.
sanction plan. Not may just complete. So, the Honorable Single Bench, after taking instruction, obtaining instruction from the state, which also said that it cannot be made part of the association, the Honorable Single Bench passed an interim order, not challenged by them. At the time of extension, my lord, they came up with a notice that we shall stop providing any services. We pointed out, we'll leave the property. We pointed out that to the Honorable Single Bench. The Honorable Single Bench said that since there's an interim order that you cannot form the association right now, it is a necessary consequence that you have to maintain under the RERA Act. So kindly maintain for the time being, subject to payment of the charges. This is the position, my lord. Now they want to leave, the single person leaves, doesn't pay.
What they have actually done is, now, my lord, conveyances are in their favor. So, my lord, until the time they do mutation, I can't, my lord, do amalgamation of these 2 plots of land. So here they won't do mutation and I won't be able to amalgamate. And now they've ensured that I can't register the society. And then, my lord, half of them don't pay. So every month, my lord, lakhs of rupees outlay and I have to maintain it, because till the time association is
Well,
formed, I
kindly-
can't run away.
Kindly see section 11
In
once.
this situation, I am really not to blame because I have purchased the next property. It's part of the same boundary wall, and I have conveyed that property to the flat owners. This is a stalemate.
Kindly take up 11
Have we
subsection
stretched out
4
before the
D.
learned single judge?
But kindly, my lord, permit me not to maintain in case they don't pay me.
11
Learned judge has said so, but we will clarify. Because learned judge has said subject to the charges being paid by the flat owner.
Yes.
No, no,
That is already there.
So now what they say is,
if out of 10, 8 paid,
yes,
how you have demarcate or the area?
this is exactly what they are
Most
doing.
of them are paying.
So out of 10,
do not pay, then what?
so my lord, out of 10, 6 will pay, 4 will not pay. Now if 4 don't pay, I have to pay from my pocket.
Majority is paying.
This is the unfairness of the matter, my lord.
Entire property.
No, why, my lord, what is the problem? What I did was, I reduced the number of guards. They are unhappy with that. They want,
No,
my lord,
there's no
20
complaint to
guards. So if
They can do
if
that.
40% don't pay, I reduce it to
There was
2
an
guards.
interim order. Suddenly they posted up notice that we are going to leave the property from
Instead
tomorrow.
of garbage
pointed out to
collection
the court.
every day, I do it alternate day to reduce costs because 50% don't pay. I have a 40 lakh claim against them. But what they want to do, this is so unfair that you don't pay and it will continue.
If a single person doesn't pay, they will leave. That will not,
Milord,
the entire will not maintenance.
On his behalf. Then,
Milord,
Yes.
what,
My lord,
what is the problem?
we are paying our share, my lord. We are
Your
paying.
share will not do, Mr. Banerjee.
But can a flat owner pay not 40 lakhs? The appellant 40 lakhs, he is saying it is due.
Forget about 40 lakhs. Forget about 40 lakhs.
We are
We are
paying
not.
our share,
Start from today.
We are not on 40 lakhs. From today,
my lord.
if all of you do not pay, why should they bear the financial burden? You say majority is paying.
No,
Doesn't help.
It is subject to my lord payment, no doubt. The statute also says
Correct.
on reasonable charges. We are paying our charges, so that they
Your
cannot
paying
stop.
will not do. Everybody has to pay.
In that event, my lord, formation is stayed by this honorable court. Formation cannot be done. The court has without
But the
amalgamation.
majority, you coerce them to pay then.
Milord, may I
Statute
suggest
says, my
something?
lord, formation
May I
shall be done with
suggest
the
something?
developer.
Mr.
till that-
Banerjee has prevented, Milord, the formation
No,
of
we have not.
association.
Court has prevented, my
Let
lord.
him go, collect from everybody and make over the whole amount to me. I will
Court has-
100%, Milord, do
Take that
everything.
My lord,
responsibility.
the statute enjoins the duty on the
Forget
developer.
about the statute for the time being.
You have stayed everything.
There's
Now
a
you
stay.
collect.
Association has not been formed as yet.
Because of
You
the-
have obtained the stay.
yes.
You have obtained.
Because not what they were doing, my lord, they were trying
No,
to bring.
because now that you have obtained the stay and there is no association, and your apprehension and grievance is that they are they will go away. Take the responsibility of collecting the charges, maintenance charges, hand over to them. We will direct them to continue.
I willingly will do it. I have no problem.
Subject to correction, but the issue remains whether without
Not
amalgamation.
by this way, my lord, they are not trying to make not the interim order, my lord.
What interim order?
The interim order is there, my lord, that they cannot leave. They cannot form.
No, I won't
that is
leave.
the-
You give me the money, I'll
No, but
maintain
it's
it.
not my responsibility, my lord, to collect. It
But
is
you
his
have got the
responsibility.
stay.
Your clients will not even take the responsibility. So we are clarifying, even if one person doesn't pay, they'll be entitled to stop.
Only there's not a single society, my lord, where, my lord, all the flat owners pay. In those cases, there's a salutary consequence how it shall be realized.
So
That is, my lord, on the person who is collecting.
For the direct response, may I just, the issue remains whether without amalgamation beyond the project area, whether the promoter can not register the society. That is the issue.
that is
That
for
legal
your
issue.
benefit.
The state
For the
authorities-
purpose of benefit, for the emergency suddenly appear, they are trying to solve this.
No, my lord,
They are
there
not-
was an agreement that I will be provided car parking within the project area. They suddenly by their own, my lord, made a my lord, conveyance in respect of a separate plot, and they said, now I am going to my lord, without amalgamation. We have agreed that very well. In respect of separate plot, where is a barren land, we are agreed.
Mr. Chaudhary, Mr. Chaudhary, you
Without-
withdraw this appeal. It's very clear, the order.
No, Milord, but it doesn't say.
Subject to payment of charges by the
Milord,
flat owner.
So 50% people will pay and file
By the
contempt.
flat owners means all the flat owners.
Kindly, Milord, clarify that and dismiss my appeal, Milord. Kindly clarify that. Otherwise, this is totally unfair. Please look at the larger picture. I have, my lord, bought that extra land, conveyed it to the flat owners.
Since you are not maintaining only for 2 persons.
Let them know it's not that, but it's not 2 persons. 25-30% people don't pay.
Let them show me who are not paying, Milord.
In the appeal, not even.
There might be blocks where everybody is paying. Let them clarify.
No details.
We recorded in our order dated November 13, 2025 that the real grievance of the appellant is that it has been directed to continue maintaining the concerned property subject to the charges being paid by the flat owners. Stop. This is an interim order. Stop. The writ petition is still pending before the learned single judge. Paragraph. We really do not see why the appellant should be aggrieved. Stop. The obligation that has been imposed by the learned single judge on the appellant for an interim period is subject to, is to be discharged by the appellant only if the flat owners pay the applicable charges. Stop. Paragraph. The appellant says that several flat owners are not paying the applicable charges. Stop. That burden has to be borne by the appellant. Stop. This is unfair. Stop. Formation of an association has been interdicted by the learned single judge at the instance of the writ petitioner. Stop. Had the association been formed, the responsibility of maintaining the property, then it would have been of the association.
The association.
Would have been that of the association. Stop. Paragraph. We clarify that if all the flat owners do not pay the requisite charges for maintenance, it will be open to the remaining flat owners to ensure that the share of the defaulting flat owners is paid to the appellant. Stop. In that case, the appellant shall continue to maintain the concerned property subject to further orders of the learned single judge. Paragraph. The appeal and the connected application stand disposed of.
Let the appellant will not intimate us not who are the flat owners who are not paying, because unless that is kindly record that.
Dispose of করার আগে the appellant should intimate to the petitioner the should furnish to the writ petitioner particulars of the defaulting flat owners so that the writ petitioner may do the needful in that regard.
Including all the particulars. So
Yes,
which
yes.
month?
Yes, we'll do that. We have also, my lord, since my learned friend said the earlier interim order, we have also, my lord, filed an appeal. That will also come up in a day or two before your lordship.
Oof.
Because we want a solution for this.
Good client.
You originally said that. The chief electoral officer.
Item number 1.
I'm appearing for the applicant. I'm just praying for a pass over, Your Lordship. I'm being led by Mr. Ray. He's on his legs.
Mr.
Anirban Ray.
Passover, I don't know what.
The next matter is mine, it will go on.
It will go on.
Yes.
Passover. You are for the respondent in number 1.
Yes, my lord.
What is the dispute about?
My lord, this relates to, my lord, a show cause notice given. My lord, to show cause, my lord, as to why, my lord, they should not be suspended. And, my lord, the bank guarantee to be invoked. My lord, they failed to get any interim order. From an interim order, my lord. Matter came up on appeal. No interim order. Bank guarantee has been encashed. Now, the only question to be decided in the appeal is whether, my lord, show cause should be proceeded with.
Writ is pending.
My lord, this is, my lord, in a writ petition. My lord, these...
Writ is pending.
Yes, yes.
Then why should we interfere?
No, writ is dismissed. Writ is dismissed.
The impugn order has been passed on 15th.
My lord, time was given, my lord, extending the time to, my lord, respond to the show cause. And they have not responded.
May I indicate, Your Lordship? Then, if my lord
This
is...
is, my lord, the issue.
Passover, you said Passover? Okay. No, we are happy to hear you. You want to argue it?
Lordship. Then I'll address Your Lordship. Lordship kindly comes to the impugn order at volume 2. 161. Before I proceed with the impugn order, Your Lordship, I'll just indicate the facts. The appellant before Your Lordship is a successful tenderer floated by the respondent. The respondent being into the office organization of election commission for holding election commissions. The appellant was given a tender to provide all the camera services and the other services which are required for vote polling countings.
Polling counters.
Yes. So this election happened.
Which election was this?
Your Lordship, this was the Lok Sabha elections which happened in 2024. 17th April 2024, that phase in the entire state of West Bengal.
Entire West Bengal?
Entire West Bengal. Different districts of West Bengal, entire West Bengal. So there were separate election commission officers, polling reports, everything was there. The appellant successfully completed the work. And the terms of the contract provides, once I successfully complete the work, the entire district in the entire state of West Bengal, all the polling commission officers will give me a successful completion certificate, which I received.
In a district, there must have been hundreds of polling.
Yes. I'll just put the exact numbers, Your Lordship. I am just 20, there are total 24 districts. I have received all the certificates. Having received the certificates, the contract provided a value. It's around 1 crore something figure. I'll just put that. I received 90% of the payments. Thereafter, in about May 2025, I write to the authority and say, look, I have completed my entire thing. After completion, you have issued a payment order where after certain amount of deductions for non-satisfaction of my work, you have paid me the every payment. So my earnest money which was with you and the performance guarantees which I gave to you for successful discharge should be given back to me.
Performance guarantee was for the sum of?
One was for the sum of 60 lakhs and the other... One second, question. Performance guarantee. No. One second. Gang guarantee what amount it It was to the tune of 64 lakhs, 2 crore odd something, the total.
2 crore?
2 crore. Because there were 2 phases, so I was given 2 guarantees and there was an...
And the contract value was for 1 crore something?
Contract, there was a... I'll just... One second.
Your Lordship, the one guarantee was around 68 lakh rupees, and the other guarantee was for a sum of rupees 1 crore 91 lakhs. The contract value was in excess of 2.5 crore odd.
So here also 2.5 crore.
Yes, yes, yes. My mistake, Your Lordship. That's the reason. I make a request to them, since you have after deductions made the full payment, after deduction, whatever it is, made the payments. So release my earnest money, which I paid of 10 lakh rupees, and also the guarantees. Based on my request, I don't receive any response. I receive a show cause notice. The show cause notice gives me, in the intergram, before I get the show cause notice, before releasing the payments, they ask me many queries of non-performance obligations, which I respond. After receiving all my responses, the final payment was released to me. And when I make a request for release of my guarantees, I then receive a show cause notice. The show cause notice provided 5 issues on facts that I have not performed, on which the entire payment was received. And then there was 2 lines which said, if you do not give a satisfactory response, we should at be liberty to encash the guarantees and also proceed with blacklisting. So this question came in. So as your Lordship knows, I am, since in the contract tenderer, I undertake this activity for all the states. So for me, every time when I participate in a tender, I have to give a written declaration that I have not been given any show cause where I have been threatened to blacklist. So at that stage, I come to the writ court. When I move to the writ court, since my learned senior friend pointed out that, yes, look, the question of performance or non-performance is a disputed question of fact. And since he has been given a time to go to the authority, so the writ should not be entertained. We rely on a Supreme Court decision. On our contention was, look, the authority is acting arbitrarily, where I completed my obligations, I receive my payments, and only when I ask for my bank guarantees, they write this. And why this become important? Because, Your Lordship, the bank guarantee which I wanted, the claim period after 1 year expires in August 2025. So naturally, because they do not have any chance to ask me a renewal or an extension, and they were never sought also. So I presume that everything is done I am entitled to in terms of the contract. The writ court did not interfere, only extended the time to file a show cause. I moved in appeal. Initially, when the appeal was being heard, and this, while we're moving the appeal, this decision of the court came in where it said, look, when the authority which is considered the obligations, where it gave me the payments, where I receive all the completion certificates, the question of non-performance of obligation does not arise. You could have called me an explanation, but you have put me with a threat that if you don't, I will blacklist you. Now that expression, blacklisting, was troubling us, because now the other elections are coming into foreplay, and I have to give an undertaking everywhere before every authority that I have not been received any notice of blacklisting. So our challenge was limited to that extent. This was being considered during the court proceedings. When we moved the writ appeal, an assurance was provided that nothing will be done in the intergram. It was said nothing will be.
Assurance was given to the appeal court.
Assurance was given to the appeal court.
No assurance.
There was the oral assurance. My learned
Lord, I appeared, there was no assurance. Date was fixed, matter didn't appear on that date.
Coordinate bench, not us.
No. There was no assurance.
So this was the, we'll make our submission.
And then, my lord, there was change of determination. My lord, the bank guarantees were expiring. No attempt made to, my lord, mention the matter, my lord, for listing or anything. 31st August was the last date, my lord, for the expiry of the bank guarantee.
So in the intergram, when after vacations we came in, 31st August, last date was the expiring of the bank guarantees. So without even notice, my bank guarantees were encashed. I write to the authority, I put it in a supplementary affidavit, whatever it happens, because that the entire episode, what my learned senior is indicating, is there. I mean, it's available. My only point of challenge today having the petitioner having completed successful performance of the work, receiving completion certificates, receiving the entire payments after deductions, the respondent now comes up and say there are issues in your performance, and if you do not give a satisfactory explanation, your securities will be encashed, which has been encashed, and you will also be with a threat of blacklisting. This is all I am on. I am aggrieved with that notice. I could have happily go back and explain the authority, but I am aggrieved with the action of the authority, where the authority has predetermined that it will blacklist me.
It will blacklist you provided you can't give a satisfactory answer to the queries.
Your Lordship, now kindly visualize the situation today. All these queries which have been raised, all the letters were already provided, and only then the payments were released.
No, that's a different question. But you didn't even attempt to respond to the show cause.
Your Lordship, there was an order where extended it, and we said since the issuance of the show causes without jurisdiction or arbitrary, so we had come into the writ court filing that. I am on a limited point. I will just try and satisfy to that extent. If your Lordship says that, your Lordship, kindly visualize, he puts me on an embargo, having performed, that if you don't give it, I will blacklist you.
That you don't give what? If you
I don't give a satisfied response, I will blacklist you. But the responses were already there with him. And on that responses, he received my payments.
Show us the notice, show cause notice.
Notice Volume 2, 159. 159. Page number 9. The response. My place it, your Lordship.
We'll read it.
I'm being led by Mr. Ray, your Lordship. Kindly gives me.
Yes. You regain your breath. We are going to read this. Then you can take over. You want some water? Seriously? Impugned order.
Lordship, impugned order starts from page 161. From 163.
Yes.
And obviously, my lord, there is a clear case of David versus Goliath. Yes. In more cases than one, in more reasons than one.
Yes.
So, my lord, obviously, your lordship has seen the facts of the case, my lord. My lord, here is a contractor who had entered into a contract. Kindly gives you 2 minutes, my lord. I'll just do a small background. My lord. Here is a contractor enters into a contract with the chief election officer for the purpose of putting up cameras. The contract very clearly says that how the payments are to be made by them. Payment was to be made on a precondition that I get completion certificates from the various district officers that yes, I've completed. On the basis of that, I'll be made payments. The contract also provided for any kind of deductions to be made before this payment is made to us. And as a matter of fact, my lord, it also provides specifically the percentages of deduction. If I have not worked properly, that should be there. And if I'll show your lordship the payment, ultimate payment.
Ultimately, did you file a reply to the show cause?
No, I did not. I did not. I'll be relying on a Supreme Court judgment, very recent judgment, that going to a person who has already made up his mind, and after your lordship sees the facts, my lord, whether I can go to this authority and get any relief. I'll show that judgment, because why I'm saying this, that's why I'm trying to give a small background. My lord will kindly I beseech your lordships that yes, I do understand the law is show cause notices ought not to be touched and things like that. But sometimes I think the facts require such a course of action to be taken. And I'm trying to take that point itself. Now, my lords will kindly appreciate, after deductions, I get my payment. My bank guarantees were only for the purpose of securing that period of time for the works which I had done. Now, my lord,
performance guarantee.
Performance. My lord, whatever they are raising in this show cause notice, my lord, these your lordship will find have been raised earlier, considered, deductions made, then payment made. Now, where does this entire thing start and culminate from? When I ask for return of my bank guarantees, and not only my bank guarantees, there were 2 earnest money deposits in cash. When we asked for it, first there were not too many answers, then this show cause notice with a threat of blacklisting. So today now, your lordship will consider 2 things.
In that notice, there was a threat of blacklisting.
Yes. Page 160, my lord.
Yes. Yes.
And appropriate penalties.
Yes, yes.
But I do appreciate that I am supposed to give a reply. But to this, what is the reply? I have a comparative chart also, which has been made out. Most of the events are prior to the final payment being made.
That is what you should have said in your reply.
Why? What will I do there? Today, I came to your lordship's court to get an injunction on the bank guarantee. It was moved before a division bench, my lord. I was making submissions. Then, my lord, it was found that time was not good enough. But I don't want to go into the nitty-gritties as to whether they were required to, but I thought that at least there was some kind of falling from the other side, that we'll wait till the next hearing. Now what they do, my lord, they don't wait for the next hearing. They invoke the bank guarantee. Now, what will I get from this authority? Do I get any chance of any? If they've already made up their mind, they're going to invoke my bank guarantee. The next step is they will go for a blacklisting. So what will I do going there?
That is why I was before this court. It was an action which was completely arbitrary, unfair, unbecoming of the state. Where I have completed my work, and then they decide that no, if you ask, they're asking for the money, I will immediately invoke and then blacklist. But I do appreciate my invocation, I do appreciate it, they might have a chance. Is blacklisting not a threat there? It's a complete threat. What will I get out of that? Going to that person?
Mr. Roy, the blacklisting, they did not say they will blacklist you anyways. They said if you can't provide a satisfactory answer. Now, you chose not to provide an answer at all.
Well, it kindly appreciates, my lord. There are two parts to it. One is invocation of the bank guarantee, which they have done. Then blacklisting.
They have blacklisted you.
No, they haven't. But that was the threat in the show cause notice. Well, it kindly considers the sequence. I asked for my money. When I asked for my money, when I asked for my BT return, then all these start.
They are saying that, sorry.
Mr. Roy, the money has gone out of your account.
My lord, I'll be praying for a return of that.
Very, very tough.
I will argue, my lord, because I will have to bring on record.
What we can do for you at the highest, we have read the order also. It is an eminently sensible order. Prima facie, it appears to us. What we can do at the highest, what the learned single judge did, is to extend the time period to file your response to the notice.
Well, let me argue, my lord, your lordship will pass orders, my lord, kindly, my lord. Well, may I just take your lordship through the papers, but not too many, my lord. I'll just try and...
Camera switched on.
Oh, see.
Oh, sorry.
Oh.
Yes.
But I will kindly straight away come to the agreement. Paper looks here. But the agreement starts, my lord. Practical of the paper movement. 71. Well, sorry, well, it's 71 hours. 71, I'm sorry. And this is more or less the same as that of the notice inviting tender, my lord. I will kindly come to, my lord, clause 3.21, my lord. Sorry, my mistake. I'm sorry, my lord. I have some problem with my the page number had some problem. I'm so sorry, my lord. But it straight away first comes to, my lord, I'm sorry, my lord, comes to the expression of interest, my lord, page 54. And this is the mode of payment.
Yes.
Payment will be made as mentioned in the terms of the agreement and will be paid on receipt of the bills on the basis of the satisfactory completion of the work within the given time frame, duly certified by the district election officer. Payment will be made taking into consideration taxes, cess, duties as per law. No advancement will be made for payment at any stage to be made. The work has to be executed to the satisfaction of the authority. So, Mala, that is the precondition. That I will get payment if there is satisfaction. So, Mala, if there is payment, then it entwines with itself that they were satisfied. Then kindly sees, Mala, requirements of total number of the IP cameras, charges, depending on the actual requirements, but that's not too much here or there. That kindly takes the next clause. The selected bidders would provide with 100% server network and power uptime as standard. This shall be applicable during the election day as declared by the client and shall be applicable for 24 hours set by the client. The bidder should ensure. Then, my lord, there is a division as to how percentage of work that can be done, and if it is not done, how much deduction will be made. And see the chart, my lord. Then, my lord, on terms of this terms, this was incorporated into the agreement. Work order, page 84, more or less the same conditions. Then kindly sees, page 84, annex P2,
84. This is the agreement.
Again, again, for some reason, my pagination has gone. I'm so sorry.
Tablet. What do you call this thing?
This iPad,
iPad. Brother side has sabotaged you.
That he would. This is dated 31st of January 2024.
Work order is dated 13th April. It's pages 67 to 69. আমি বলে দিচ্ছি আমার দিকে তাকাও better resistance 67 to 70 স্যারদের সঙ্গে খালি কনফারেন্স করলে তো হবে
When it will kindly comes to this would be
Your Lordship heard about Goliath and David. Entire morning, entire evening, entire morning today, entire evening yesterday, my learned friend was in conference with Mr. Harish Salve to appear against me.
That's what I meant, but the two Goliaths, I will leave it all around.
I was the David there.
No one will appreciate this one. But this is page 67, this is a letter dated 13th April 2024, these were regular modifications which were made by the Chief Election Officer. Kindly sees upon these are subsequent requirements for further services. But I'm not on that, I'm just trying to take your lordship to page 68, kindly sees. Page 68. The penultimate paragraph on that page, The payment in this regard will be made to you on receipt of your bill or invoice in triplicate, along with the certificate from the concerned district election officers on successful completion of the work. So, that same clause, is being reiterated. Now kindly comes to page 102. And from page 102 to 126, these are all completion certificates provided in terms of the contract. 102 to 126.
102 to
126. These are all the completion certificates. And takes any one of them, kindly sees successfully completed the supply. These were the 24 districts where we were giving the supplies, and this is what we got from them. Then kindly comes to page 127. Payment कुछ है? Sorry, kindly comes to page 150. 150. Page 150.
150.
150. This is the payment made. Now, kindly keeps note of the date. 30th of December 2024.
Can hardly be read, but
This is sanction.
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 Not the payment.
Not the payment.
Sanction is the expenditure.
Yes.
No, this is payment. May I just read it, your lordship can see.
Very illegal.
Sanction is hereby accorded to an expenditure amounting to rupees 29 lakhs. So, sanction is for making the payment.
89 crores.
29 crores. So, the sanction is granted.
The contract value was 29 crores.
Yes.
Your junior told us 2.5 crores.
29 crores.
Told us 2.5. Yes, it's a 4 crores.
Was payment of marginally noted bills, can you see? Submitted by FOCOM for webcasting solution for live monitoring of the poll-related activities in connection with general election in Lok Sabha 2024. Work order in this regard was issued on such and such. It's the same. Now, can you see, deduction of claim has been made as per clause 3.21 of the NIT.
You better give us a better copy of regimental copy of this. What a product.
Type it out, then.
Anyway,
we'll give it tomorrow.
You may not conclude today, it seems.
Sorry,
To conclude. Lot of time left. Mr. Mukherjee can start then.
Come tomorrow.
No.
And kindly takes. Deduction of claim has been made as a clause 2.1, 3.21. Now, kindly sees this chart. Invoice amount taxable. Kindly see the third column on the top one. Invoice amount taxable amount is rupees 2350. Your lordship got that?
Yes.
Just after that, the next column. deduction on the claimed amount as per the recommendation of the IT steering committee and scrutiny by the webcasting cell of this office. So this same office, after giving me a completion certificate, accepting that 3.21 they'll make deductions, makes payment. The precondition was completion certificate satisfaction. To their satisfaction. If they were not satisfied, they would not make the payment. Now, my lord, sorry. Now, my lord, then is the entire thing which starts. After this, my lord, obviously I asked for my bank guarantees back. Kindly see 16 January 2025, P12, page 152. My lord, here I have started asking for that bank guarantees back. And for earnest money, 152.36. Well, this will continue till page 157, Malad. 4 letters given till 31st May 2025. And then comes the show cause. Seeking clarification relating to webcasting in Parliament General Election 2024 release of AMD and bank guarantee. I'm directed to that you had been assigned the work of live streaming such and such. And then 2, Malad, remind you by letter of such and such of 6 May, clarification was sought regarding the details of camera along with the time frame during which they had become offline in first and second phase.
We have gone through this, Mr. Roy.
Now,
several deficiencies, according to them, have been pointed out.
I'm trying to point out, my lord.
No, we have got your point. That these, having considered these, having made the deduction, having been satisfied that we have completed the work successfully, having issued completion certificate, having made payment, this is afterthought, mala fide, just to cling on to the bank guarantee and invoke it. This is the crux of your
I'm trying to show the date because of that. All the completions that will come after these.
After 7 July?
No. After the dates mentioned in this 7 July letter, my lord.
I see.
That is what I'm trying to say. But how much unfairness can I show?
Completion certificates are 102 to 120.
Onwards, my lord.
Dates, let us see. Kindly see, my lord. 102 onwards, my lord. They are dated 23rd of April 2024. 23rd of April 2024. What you say is not factually correct, Mr. Roy.
My lord, I'm not saying factually not correct. What I'm saying is, my lord, after these considerations, they've given those completions.
The dates mentioned in this letter, show cause, are dates subsequent to the dates of the completion certificates. Completion certificates, for example, 102 is dated April 24.
On the basis of these completion certificates, when a payment is being made in December 2024.
Correct.
And the complaints are within that period. Well, kindly see 7 January, July, Malad, kindly once, Malad. They refer to, Malad, para 2, that by letter of 6th May 2024 clarification was sought.
Oh, payment was made when?
December 2024. Well, that is what I'm trying to. Why would they do this then? And in spite of them deducting in terms of the contract. How will you about it? And then Malat says, Malat, why if the subsequent conduct has to be seen by your lordship, Malat? Malat, what has happened, Malat? Malat, after the appeal was moved, Malat, they suddenly issue a letter, Malat, which is at 213, well, supplementary affidavit, Malat. I think I might have gone wrong because I thought that the respondents had not been able to complete on that day, and they said that at least till the next hearing they would not take any steps. But whatever it is, my lord, in this letter, what do they say? Kindly see, my lord, whether this is a malafide approach or not.
213 is not legible.
214, my lord, sorry, my lord, it's a typed copy, my lord. In continuation of the above mentioned reference, I am directed to inform you that 2 bangles were executed by FOCOM for the purpose of implementation of webcasting. In all polling banks and such, the validity of bank guarantee bearing numbers with an amount of such and such. Show cause has been issued to the authority for defaulting in regard to the work assigned to them, and a court case is pending with Honorable High Court. In this company situation, I understand the director request you to invoke the bank guarantee. Just because I've come to court.
Expiring.
In this situation, Malad, is there any? I heard Mr. Mukherjee making a statement, Malad, it's expiring. But has there been any request for extension? It specifically says that in the compelling situation, since there is a High Court case, I'm invoking the bank guarantee. I had asked for a interim order, but I thought that the other side will complete the next day. The judge, but it's bad luck of my client. I must say that the determination changed on that date, and there was no recording. The recordings are all on YouTube. We don't show YouTube, so we are not on that. Sir, আমি সেটা তো বলছি না, আমি তো আমার নিজের এতে বলছি যে I have understood wrong. But I am on the conduct of the respondent. I am showing the letter. I don't want to know what is there, what is not there, what has been said. But since it's not recorded, I understand, Malat. I'm not on that. But is this a ground? Malat, this itself shows that I will not get any kind of justice in the show cause. Cannot be. And Malat, I beseech that this post facto conduct should be taken into notice, Malat. And that is why I did not go there. So, Malat, this is the situation, Malat, where, Malat, my learned friend's client has issued this notice. Now, Malat, may I just, Malat, first things first, let me try and ward off the show cause, Malat, not to be. Malat, there are certain points, but I don't know, I'm too small a fry to say all these things, Malat. But, Malat, I always believe, Malat, a few things, Malat, like a bank guarantee, Malat. Malat, after being in such certain position, Malat, for some time, I understood how it's a completely, Malat, it's a type of putting pressure on. It's a sword. Mr. Mukherjee also knows. It's a complete sword, but we don't give effect to that because the law is such. And I beseech your lordship that this should be taken note of. Just because I would be thrown out, invoke a bank guarantee. Just because I will be shut down, issue a show cause. But kindly see it now. May I just place the sorry.
In many cases, the aggrieved person may have a very good case on merits.
Definitely.
Forum may be wrong. It's not that you have no other
forum. You don't have any forum.
Of course you have forum. Anyway, we are not. We have stopped advising these days.
This, Malat, Matlab, then matlab, I have come because it's a state. Matlab,
Here
couldn't have been more of a state than the chief election officer. Matlab. Couldn't have been more of a state.
No, we are not on Article 12 at all. We are not on Article 12 at all.
But alternative remedy, matlab, again, I would submit. Matlab, I will.
Not a bar, not a bar. All granted. Make your submission.
Yes. Matlab, may I rely on a judgment? No? Of the Honorable Supreme Court, matlab, how much I can, matlab.
You cited this before the learned judge?
No, I did not. I got it a bit later than that, matlab. Just have to Party wala.
Given from SCR. We have SCR.
What is this INSC?
These are all, you know, and I think, you know, what is this? No, INSC. This is Supreme Court reports, I believe, which is supposed to be
Supreme Court. IN is what?
I think the citation of the Supreme Court now, because they have this neutral citations. That nowadays is neutral.
Yes.
And it will kindly see this. But the place of
battery gone.
Comedy of errors.
Don't you get power backups for these like mobile phones?
I do, but I did not realize that it's going to go for a toss right now.
Lord, INSC is India Supreme Court.
Indian Supreme Court.
India Supreme Court.
Yes.
This is a neutral judgment to the citation. I will first read the relevant paragraph, and then I will try and take your lordship to the main facts of the case. But here was a case, where also a blacklisting was threatened.
Mr. Roy, you think we can release your learned friends in the other matters? They're waiting. Half an hour time is left. Mr. Mukherjee, you're also there. So even if he finishes, you will start.
Yes. Oh, I can do two matters, Melody, either way.
Yes. So yes, release. When accepting এইটা পরেরটা এই দুটো ছেড়ে ওটা
All the other matters from 3 to item number 6 are released for today.
From 229 of the running page, your lordships will kindly look into it, First, the Supreme Court refers to the Gulja Industries judgment, Para 25. Para 25 onwards. Talking about the power of the authority to blacklist a company, and that 6 the blacklisting was looked into after the final order. Now, considering this situation, para 29 However, what is important for us to say is that when there are guiding principles explained by this court as to when and in what circumstances the blacklisting order can be passed, then, in our opinion, such principles should also be borne in mind by the authority at the time of issuing a show cause notice. We may say so because in the facts of a given case like the one on hand, on the face of which it could be said that there was no good reason for the authority to issue a show cause notice, calling on the contractor why he should not be blacklisted. Why ask the contractor to face the person when applying the aforesaid to the issue of show cause notice to be an empty formality? We are saying all this keeping in mind the particular facts of this case. Therefore, the authority is expected to be very careful before issuing a show cause notice. They expect to understand the facts well and try to ascertain what sort of violation is said to have been committed by the contractor. As noted above, there is always an inherent power in the authority to blacklist a contract. But possessing such inherent power and exercising such power are two different situations and connotations. There may be a power, but there should be a reasonable ground to exercise such power. To put it by way of illustration, police has the power to arrest, but it is not necessary in all cases. Arrest must be effected. The police should know whether at all arrest is necessary. We may put it in a slightly different way. Take, for instance, the show cause notice in the present case, the final order of blacklisting. Final order in any case cannot travel beyond the show cause notice. Therefore, we take the show cause notice as the final order. Whether it makes out a case for blacklisting, this should be the test to determine whether it is a genuine case to blacklist a contract or visit him with any other penalty, forfeiture, VFD, recovery of damages. We say so because once an order of blacklisting is passed, the same would put an end to the business of the person concerned. It's a drastic step. Once the final order of blacklisting the contract is passed, the contract is left with no other option but to go to the High Court invoking the jurisdiction and challenge the same. If he succeeds, the single judge, then it is well and good. Otherwise, he may have to prefer a writ appeal or LPA as the case may be. This again would lead to unnecessary litigation in the High Court. The endeavor should be to curtail the litigation, not to overburden the High Court with litigation of the present type. More particularly, the law by and large is very well set and there is no further scope of any. As observed by this court in judicial equipment, an order of blacklisting casts a slur on the party being blacklisted and stigmatic. Given the nature of such an order and the import thereof, it would be unreasonable arbitrary to visit every contractor who is in breach of his contractual obligations with such consequences. There have to be strong, independent, overwhelming materials to resort to this power, given the drastic consequences that an order of blacklisting has on a contract. The power to blacklist cannot be resorted to when the grounds for the same are only breach or violation of a term of a condition of a particular contract, and when legal redress is available to both the parties. Else, for every breach or violation, though there are legal modes of redress and which compensate the party to the corporation for us to resort to blacklisting at times by abandoning or scuttling the pending legal proceedings. Like in this case, one of the bank guarantee was invoked. Then, plainly, if a contractor is visited with the punitive measure of blacklisting on account of an allegation that he has committed a breach of a contract, the nature of his conduct must be so deviant and aberrant so as to warrant such a punitive measure. A mere allegation of breach of contractual obligation without anything more per se does not invite any such punitive action. Usually, by passing tender, the bidder is required to furnish a statement. Kindly click 36, next paragraph. 35 দেখো নিশ্চয়ই Mr. Mukherjee wants me to place para 35. Usually, while participating in a tender, the bidder is required to furnish a statement undertaking that has not been blacklisted by any institution so far. And if it is not the case, provided information of such blacklisting, this serves as a record of the bidder's previous experience, which gives the purchaser a fair picture of the bidder and the conduct expected from it. Therefore, while the department itself may not be permanent, may only remain effective for a limited predetermined period, its negative effect continues to plug the business of the debarred entity for a long period of time. As a result, it is viewed as a punishment so grave that it must follow in the wake of an action that is equally grave. In the overall view of the matter, more particularly the peculiar facts, we have reached the conclusion, asking the appellant herein to file his reply to the show cause notice and then await the final order, which may perhaps go against him, leaving with no option but to challenge the same before the jurisdictional high court, will nothing but an empty formality. Even otherwise, issuing of show cause notice, if not always, then at least most of the times is just an empty formality. Because at the very point of time the show cause notice is issued, the authority has made up its mind to ultimately pass the final order blacklisting the contract. In other words, the show cause notice in most of the cases issued with a predetermined mind. It has got to be issued because this court has said that without giving an opportunity of hearing, there cannot be any order of blacklisting. To meet with just a formality is completed by the authority of issuing a show cause notice. And precisely that is also what has happened in this case. They have only issued the show cause notice, first with a threat and then to compensate this, they take the money also.
So there are two aspects. One is forfeiture, one is blacklisting. In this case, forfeiture was permitted expressly. The earnest money deposit was permitted to be forfeited. 37.
Yes, Malad. Malad kindly appreciates, Malad. It does not make it mandatory that if it's a show cause notice, you have to go before the tribunal, whatever, the authority. Malad, I am trying to show your lordship the facts. Kindly look into the facts, Malad. Well, here is a authority which first asks me, it is not his order that you have not filed your reply, therefore I am invoking. He says, since there is a court case, I find it necessary to invoke.
Since tomorrow is the last day, court case is just mentioned. It is not that since there is a court case.
My lord, if it's tomorrow is the last date, my lord, there has to be a requirement for extension. It's a contract which is stood closed on making payment. My lord, why will the authority, my lord, I'm just asking myself this question. Why will the authority get so much of leeway on such facts? That is what I'm asking. Where they have had their share of deduction. They have not given any explanation that after deduction we found there are supposed to be further deductions. They have already deducted from my completed payment. What more deduction will they make?
Usual unconditional bank guarantee.
Yes, ma'am.
How do you injunct that?
Sorry, madam.
How do you injunct the invocation?
I have never sought for an injunction for that. What I wanted that this notice should go. I was on the notice. I'm showing the bank guarantee invocation, my lord, because I have sought for that no further steps to be taken on this. What I am saying today, my lord, if the notice goes, at least I'm without any threat. I am a government tenderer.
Yes.
And my lord, I have also made, my lord, in my supplementary affidavit, I will argue, my lord, that if I can show that this is an unfair notice, arbitrary notice, then, my lord, I will be entitled to orders of restitution from your lordship's court. Because they have specified.
Mr. Roy, blacklisting and invocation are two separate things.
Sorry,
Even if blacklisting and invocation of the bank guarantee are two separate things. Even if we are with you on the point of the show cause notice being bad, their conduct, etc., etc., even then it will be difficult for us to restore the money.
I take my limitations, my lord, but I'll try and argue that much, my lord, before your lordship.
For that, you have to file a suit.
Would be referring to two further judgments of the Supreme Court, my lord, which says that if such kind of actions are seen, the court is not, I mean, your lordship's 226 court has the powers. Has the powers. That is what I want to show your lordship. Next judgment, sir. This তো পুরো বন্ধ হয়ে গেল না আচ্ছা রাজি হবে না
Tomorrow.
Kindly, man, I'm at a complete loss. Man, I don't even know the paragraphs. Man, this happened for the first time. Now I will carry.
This is an appeal
How do you say?
Against a judgment and order. A judgment and order. কোথায় গেল রে বাবা judgment order? এই আমার নাম দেখলাম একটা কোথায়
15 July 2025
না না তা বলছি না। কত কেস কথা
আমার সবচেয়ে টেনশন একদম
July 15, 2025, whereby the appellant's writ petition has been dismissed. Paragraph we have heard, Mr. Anirban Roy, learned senior counsel representing the appellant at length. Stop. He does not conclude. Paragraph. কালকে রাখবে আবার same এক নম্বর হ্যাঁ original set কখন ট্রেনে তো ঠিক করতে যাচ্ছি কালকে ডেট দিয়ে দিন No. ক্রিমিনাল অ্যাপিল আমাদের জাস্ট পেজ দিয়ে টাইম দিয়ে ফিক্স করতে হবে যাতে এই সবগুলো Yes. You want some other day? You're hesitating to tell us something.
I feel embarrassed. And I should have finished it,
But your iPad finished you.
Yes.
Call the next matter. Daku.
Last order, your lordships had given me leave to bring the subsequent events on record.
So we ensured you do two matters.
I missed one in the morning, Miller.
Yes, you did.
Okay.
You did.
Lordship, I appear for JPC, respondents number 1816.
Did we hear this matter before?
Yes, my lord, I had, my lord, started it, given your lordships, my lord, a brief background. Then, my lord, certain subsequent events had happened. So, your lordship had given me, my lord, leave, my lord, that the order, my lord, of 3rd of November 2025. Yes, sir.
Who is for the union?
I appear for the union. My lord, we would also like to file a supplementary affidavit regarding the documents, my lord, here is annexed. The stand taken by Tatas is that the payments were made without prejudice. But I have letters to show that all along they had made payments without
So you want to file a response to this?
Yes.
File it, but let's not hold up. Shall we hold up?
No. Let
We
the
can
hearing
go
conclude.
ahead.
Lordship will give me kindly 1 week's time to file
Very
the
well,
response.
we'll post this matter again after a week after today.
Yes.
And
Yes.
you can file.
Today's hearing should continue.
My lord, we had filed a notes of submissions, my lord, in this matter. Should be on record, it was shown last time. In fact, your lordship's order summarizes the whole thing. Kindly have a look at that order, 3rd of November 2025. আর এইরকম থাকবে একটা। এটা কি?
এটা আগে মেটাই
এরকম সবুজ কাগজে থাকবে বন্ড পেপারে থাকবে
Yes.
We had, my lord, filed a note.
Yes.
My lord, kindly keep that, my lord. I'll go on that basis. My lord, it will kindly come to annexure A to the note, my lord. Page 9, my lord, which is the list of dates.
Yes.
Which, my lord, gives, my lord, the facts. My lord, first date, my lord, is 1955. And my lord, the Act declared iron and steel, including manufactured products of iron and steel, as an essential commodity. This was in 1955. And my lord, Section 3 had empowered, my lord, the central government to control production, supply, distribution of essential commodities. Then we had, my lord, the Iron and Steel Control Order of 1956, which was promulgated, my lord, under Section 3. And, my lord, Clause 15 of the Control Order empowered, my lord, the Iron and Steel Controller to fix the price of iron and steel. And, my lord, Clause 17 of the Control Order, my lord, empowered the central government to give directions with regard to the matters specified. Now, my lord, that's at page, my lord, 43, my lord, 433 to, my lord, 444. But 438, my lord, is clause 15. Which I don't think will be legible. Volume 4, my lord.
Yes.
My lord, clause 15, my lord, kindly see at page 438, volume 4.
Yes.
My lord, first is, my lord, the power to fix prices. The controller may from time to time by notification in the Gazette of India fix the maximum prices at which any iron or steel may be sold by a producer, stockholder, and by any person or class of person. So, my lord, price fixation, my lord, maximum limits could be prescribed, my lord, by the controller. Then, my lord, kindly come to, my lord, clause 17, my lord, which is at page 440. The central government may give directions as to the procedure to be followed by the authorities issuing quota certificates, permits, or written orders referred to in clauses 4 and 5 as to the maintenance by the controller of records in connection with distribution of iron and steel, and generally for the purpose of giving effect to the provisions of this part. Then, my lord, kindly take volume 2. My lord, page 169 to 174. Which it says, my lord, in exercise of the powers conferred by clause 17 of the Iron and Steel Control Order 1956, the central government is pleased to give the following directions as to the procedure to be followed by the concerned authorities in connection with the distribution of iron and steel. These directions will take effect immediately. Now, my lord, kindly turn to page 170. My lord, under, my lord, Clause 17, my lord, there a joint plant committee, JPC, my lord, was constituted. Page 170, my lord, at the very start. System of indenting and planning. A joint plant committee is hereby constituted with the following personnel to take over the functions at present performed by the iron and steel controller in regard to the planning and distribution of indents and rolling programs. Now kindly see, it's my lord iron and steel controller chairman and one representative of each main steel plant. That is Tata Iron, my lord, the rest of the iron and steel company, Hindustan Steel, etc., which, my lord, all came under the purview of sale.
What to, oh, purview of sale. I see.
Ultimately, my lord, either sale or Tatas. And then, my lord, a representative of the railway ministry. And then, my lord, what it could, my lord, do, my lord, the joint plant committee is, my lord, mentioned here. Now, my lord, the first point, my lord, I wish to, my lord, make is
this Iron and Steel Company Limited became Steel Authority later. No.
Iron and steel. My lord, Tata.
No.
My lord, this was ISCO.
ISCO, Burnpur, yes.
ISCO.
Anyway, doesn't matter.
But they've all, my lord, either, my lord, whatever steel industry was there at that time, my lord, the old ones are either today Tatas or, my lord, SAIL. Now, my lord, the important thing is that, my lord, these were, yes, I have a note here, my lord, it's government companies, my lord, which were, my lord, treated, Tata was, my lord, treated at par, my lord, with the government companies, at least as far as constitution of the Joint Plant Committee was concerned. Then, my lord, clauses 17A and B were introduced in the control order, which is volume 3. Volume 3, my lord. (191) at page 203. The two clauses are important, 17A and 17B, which are at page 203. Power of central government to give directions to producers. The central government may give directions to producers and stockists of any category of iron and steel or to such other persons as it considers necessary regarding procedure to be followed in the production, dispatch, stocking and placing of orders on producers or stockists, whether such category or iron and steel is subject to or exempt from the operation of all or any of the provisions of this order. Then 17B is a power to set up committees for the purpose of giving effect to the provisions of this order with respect to any category of iron and steel, whether such category is subject to or exempt from the operation of all or any of such provisions. Central government may by notification set up from time to time such committees, bodies, others may set up authority under shall carry out such functions as may be specified in the notification under which such committee or body is set up. Then, my lord, a notification is issued on 7th of April 1971. My lord, volume 2, my lord, page, my lord, 175. My lord, kindly see, my lord. My lord, two committees, my lord, were set up under, my lord, 17B. My lord, earlier I showed your lordship, my lord, the committee was under 17 before introduction of 17A and 17B. Then, my lord, 7th April 71 comes, my lord, this, my lord, notification. In exercise of powers conferred by clause 17B of the Iron and Steel Control Order 1956, the central government here sets up two committees to be known as Joint Plant Committee, that's my lord JPC, and the Steel Priority Committee, which is SPC, for the purpose of giving effect to the provisions of the aforesaid order. Now, my lord, Joint Plant Committee composition. My lord, Iron and Steel Controller, chairman, member, one representatives of each of the main steel plants. That is to say, Tata Iron and Steel Company Limited, Indian Iron and Steel Company Limited, Hindustan Steel, Rourkela, Hindustan Steel Bhilai, and Hindustan Steel Durgapur. One representative of the so and so. Now, my lord, the functions, your lordships will find. Functions, the joint plant committee shall be responsible for carrying out generally the functions of coordinating, etc., etc. Now, kindly come to, my lord, clause, my lord, 8 first, my lord. That's page 177. The committee may determine, lordships have that, the committee may determine, announce and list prices, base prices as well as extras from time to time of all categories of iron and steel, not subject to price control under clause 15 of so and so. The price so determined will be X works prices. The committee shall add a fixed element of equalized freight to the X works prices announced from time to time in order to ensure that buyers of steel all over the country pay the same railway freight irrespective of the distance from source of supply. Committee may make such, take such measures as it considers necessary, so and so. So, my lord, what was the distance, my lord, between, my lord, the, my lord, place where steel, my lord, could be purchased actually, and, my lord, where it had to go, my lord, freight rationalization would take place so that there's parity maintained, my lord, in different parts of India with regard to price. Then, my lord, what is another important thing, my lord, 179, kindly, my lord, come to 178 actually, my lord, 13A. Shall regulate distribution and sale for all producers following categories. And then, Millard, in B, in laying down detailed procedures and systems under subpara A, committee shall ensure that demands of defense, power irrigation, exports of engineering, steel and coal, atomic, etc., so and so, and other priority sectors are met in full and only then balanced. This is how Millard proceeded. Then, my lord, on 5th of June, 1978, my lord, a steel development fund, which with we are really concerned here, was set up.
We'll resume. We'll record in order.
Yes.
Supplementary affidavit filed on behalf of the appellants. Be kept with the records. Paragraph. This matter once again on aajke koto tarikh? 25 tarikh. So paragraph, in the meantime, comma, JPC, Joint Plant Committee, capital A, will be at liberty to file its response to the supplementary affidavit filed by the appellants, comma, with advance copies to learned advocates on record for the other parties. What? Sorry?
I will if they want to file,
My lord, also for Union of India.
In the meantime, the respondents. Sure.
Next Tuesday, 9th.
Then you go and do that matter. We can't accommodate everybody in every matter. No, sorry. Your 25th is all right for others.
Yes, my lord.
Your turn will come later, Mr. Mukherjee, Mr. Dotto, they are all here.